Judgment of item number 1.
You're the amicus.
No,
I'm sorry, you're the PP.
PP.
Who's the amicus?
Amicus Melos, C section today, Junior is here.
Not she, he. Who's the amicus?
Amicus was Jitarak.
Oh, Jitarak is there. Yeah, Jitarak is the amicus. Okay.
From the aforesaid discussions, materials available on record and the evidence of witnesses, the trial court records and the case laws relied upon by the learned counsel appearing for the respective parties, we find that there is no infirmity in the judgment and order passed by the learned district and session judge, so and so. Accordingly, instant criminal appeal is dismissed.
Obligation.
Any mention?
May I beg to mention one the matter we fix for tomorrow. This one pending matter. I have to take steps by the district service. This matter, but in the mistakenly in the last order, it is written as usual court. It required it district service because it is a preventive detention matter.
Okay.
Tomorrow matter.
Item number 2.
May it please your lordship.
Yes.
This matter otherwise can be formally closed today. This is pertaining to an issue regarding a particular festival under of the Nisi community, wherein a dispute had arisen as to whether rituals could be performed or not in that festival. Now, there has been already an order passed on 28th of January. Now, based on that order, the district administration have ensured that the festival that happened in February 2026 could be held with rituals, and the state administration will have to ensure that there is no untoward incidents. Now, accordingly, the festival has been celebrated and grievances have basically been met, therefore.
Which is the order dated?
The order date?
Yes.
21, the last order.
21.
You will also see the last paragraph of the order, paragraph number 8. That takes care of our grievances, and accordingly, the festival was held with full rituals, and district administration were also very helpful in allowing us to perform.
So the sole purpose of filing this PIL was to
Because what had happened
have the festival peacefully.
Because what
You
had
are
happened in the
permitted.
previous year, there was a lot of incidents whereby the indigenous faith believers who celebrate this festival of Nokum Yelo of the Nisi community were not allowed to hold this festival with the rituals part. Only the cultural aspect was allowed to be held in the town of Sagali. That led to this filing of this PIL. Now, pursuant to that, affidavits have been filed by the respondents. The Director of Indigenous Affairs have also filed their affidavit. They have also admitted that in this particular festival called Nukum Yelo, the rituals is a integral part. In fact, they have said it's the soul of this festival. Now, based on that, pursuant to a hearing that took place on the earlier occasion, this order was passed, wherein it was stated that we may be allowed to hold the festival in the manner that it has been held by all times, previous times. So it has been held accordingly.
So this festival is a one-day affair.
It's a 5 days affair. Starts from around 23rd of February, ends on the 26th of February. Every year, annual festival. So we therefore are now hopeful that since it has been now allowed to be held, the state machinery have also come to our aid and we're able to hold it. So there should not be any apprehension for the petitioners that next year that something might also happen. So
the order indicates 24th of February. You say 23rd. 24th.
24th.
Onwards. It says commencing from 24th.
Yes.
Of February 2026.
Yes. No, later on, I was corrected by the petitioner that from 23rd, they have their initial programs.
Okay, I see.
That the priest would come. All these functions are there.
So who's respondent number 7?
Respondent number 7 is the other faction who were not allowing to hold us this festival.
Have they appeared?
No.
They have not appeared.
Notices have been served upon them. In fact,
Mm.
it has been also observed in the last order that notices were served, yet they choose not to appear. So I think the proceedings
Mm.
have therefore proceeded ex parte. There was some order for in that regard also, Lordship. Our case was basically against the government. We say that Article 29(1) gives us the liberty or the privilege to conserve our culture. And the state had to create the environment to do so. The state was not coming forward to aid us. So therefore, we had filed this PIL. The state filed this affidavit. The Directorate of Indigenous Affairs also filed an affidavit and they had supported our case. So accordingly, the order was passed on 28th of January. Pursuant to which the festival was held.
Yes, who's appearing for the other side?
Kolkata government, the respondent three specifically applies in para is saying that
Mm.
it will support.
So it can be closed then?
Yes, sir.
Is any observations required?
That last order, if it is made absolute,
Mm.
that last paragraph, I think peace and tranquility will be maintained in that area for future years to come, Your Lordship.
Okay, brother,
Yes.
close in. Please write down. Heard Mr. A. Sharma, learned counsel for the petitioners, and also Ms. G. Ate, learned additional senior government advocate, appearing for the state respondent numbers 1 to 5. Who appears? Private respondent number 6. Last time, Mr. K. Posi appeared.
Yes, they have filed their affidavit supporting our case, KPOC. That is the Central Nokum Committee.
Although respondent number 6 has filed counter affidavit, no one appears today. To stop, it is also seen that respondent number 7 has also not appeared, despite notice having been served. Stop. At the outset, Mr. A. Sharma, learned counsel for the petitioner, submits that an interim order was passed by this court on 21/2026. And in terms of the said interim order, what is that festival? The
Nokum Yolo
Nokum Yolo Festival
of the Nisi community.
of the Nishi community with rituals was carried out peacefully. At the Nokum Yolo ground, bracket Lapang, Sagali town, which commenced from 23rd of February, 2026. To stop, he submits that all the district machineries have cooperated in ensuring that the festival was held peacefully. The learned counsel submits that the affidavit filed by the official respondents also go to show that they support the cause of the petitioners. You are there?
Mr. Posi.
Mr. Okay, you right. Mr. K. Posi appears for the respondent number 6. Okay, earlier I said no one appears. That cancel that. Next para. Be it stated herein that this PIL has been filed by the Nishi Indigenous Faith and Cultural Society.
My lord, I'm extremely sorry. I was held up in the traffic. My lord, I have been instructed to appear on behalf of respondent number 7, my lord. There's certain issue, my lord, required to be, we need to file the affidavit, my lord. So maybe even the part of their pleading has not also been supplied to us.
See, the festival was held peacefully,
My lord, that is right.
and so it appears that the matter can be closed. So what do you want to say now?
My lord, only one thing, my lord, because they may, tomorrow they may misinterpret the law, my lord, because this interim orders for the purpose of celebration this year only. There's a certain, the point, my lord.
So they would like to raise the dispute in the next year. My apprehension now, I was telling my client that don't worry. I think it will be allowed to be held.
But
So
there's
they
a
want to
way
bring this
to
issue
think on
again.
this part, my lord. There's a certain point, my lord, that it is not a case, my lord. They are saying that some part of section of the people, they are not following the ritual. As a part of the festival, they are celebrating. Now, another point, my lord, there cannot be a compulsion upon the person who want to celebrate as a mark of celebration to the festival. But somebody who want to do as part of the ritual, they can do. But there's a certain, there should be also liberty. But tomorrow they may misinterpret and misuse the decision. This is a judgment.
How can there be a mandatoriness in celebrating of the function? It is always, they are always welcome.
We did
In
the
fact,
same.
it was what had happened was we were sidelined in the town of Sagali.
My lord, I'll just
Let him
clarify.
get
One
him
of
finish.
the
I'll
point, my lord.
submit.
See, you are respondent number 7.
My lord,
This is the 55th Nokyum Celebration Committee
my lord.
of 2025.
My-
And Sagali session 2024-26. This is only for this year only.
Correct.
You're not a committee which will perpetuate
No.
all the subsequent years.
My lord, that's right, my lord.
So as of now,
My lord.
that festival is not throughout the year, isn't it?
No, no.
My lord, no, not throughout the
Not
year.
January to December, the festival is going on.
My lord,
It's only once.
yes,
That has
only once.
happened.
Yes, my lord. Only my apprehension, my lord, they may misuse this, any order passed by this honorable court, they may misuse in the days to come.
How will they misuse? Please demonstrate.
My lord,
We are just saying that the thing as celebration happened as per the
Yes.
interim order.
yes,
So
my lord.
cause of action has, has been.
My lord, if that is
Can-
there, then we have no,
Ah.
my lord. But if it's more than that, my lord, they may misuse, that's one thing, my
No,
lord.
more than that, is there any prayer like that?
My lord.
Or are you expecting the court to say that? We're not saying anything.
But this year, the day of celebration, we have no problem. But
Ah.
only if tomorrow, if they,
So tomorrow they would like to again object in the celebration.
it is
That
not
what
a
he is
object.
trying to submit in this court. When the government.
Then you come, you all come again.
my
You
lord,
cannot keep this pending,
Oh,
hoping that next year, February, some trouble might happen.
Yes.
So we'll keep it pending.
Only-
Let us.
only that-
Logically, I was thinking that
Yes.
it can be closed.
that can be closed if it is. My lord, my only submission, my lord, even in the case of the committee allotment and all, it's not in the name of Nyubu Nyaga, my lord.
All right. We'll close it.
My lord.
Mr. Tagum. What did I say last line? It starts with B, BEB. B, it stated herein that this PIL is filed by the Nishi Indigenous Faith and Culture Society, a body representing the interest of Nishi indigenous tribal people residing in the state of Arunachal Pradesh. And the grievance of the petitioner is that although the cultural part of the Nyokyum Yolo festival is allowed to be
So in the
celebrated, but the
ritual aspect also,
ritual aspect has
they were
not been allowed
prevented from celebrating the ritual aspect
to
in the year
be
2025.
celebrated by the respondent number 7
in the year 2025. Lord.
My lord, sorry to say, my lord,
in the year 2025. And therefore, it is for this purpose that they have filed instant PIL. Mr. A. Sharma, learned counsel for the petitioner, submits that since the festival has been carried out peacefully as submitted by him earlier, the purpose of the instant PIL has been served and the same can be closed. Next, para at this stage, Mr. A. Tagum,
yes, Titagum.
T. Tagum, learned counsel, appears and submits that he has instructions to appear on behalf of respondent number 7. Stop. He also submits that he may be given some time to file counter affidavit. Stop. He further submits that although an interim order was passed by this court on 21/2026, the respondent number 7 apprehends that the petitioners would misinterpret the same.
To compulsorily ask them to appear in that rituals. This is what his submission is. That we will use this order,
No, 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 no.
misinterpret it, and make it compulsory upon them to also celebrate the
No,
ritual.
no, not
If
that
that
case.
is the
Not,
submission made in
no,
this
no, no,
court,
no.
it's very unfortunate.
Sorry, my lord. And this is not my submission.
That-
My submission is that this, in the same the event of celebration, my lord, some section of people they celebrate the festival without ritual. So in that account, they may make any kind of complaint that this is kind of causing sentiment to the since it's been festival, the celebration has not been done in as per ritual, my lord. So they may have a different stand, my lord, for that, my lord. For a person who is celebrating, section of person who is celebrating without ritual, my lord. That is my submission.
What was the last slide? The petitioner would misinterpret the order passed by this court so as to influence the other
Non-indigenous faith believer, Lordship may put it like that.
the other non-indigenous
Indigenous
faith
faith.
believer to also participate in the state process,
Yes.
state festival,
State ritual.
state ritual.
What do I say then? What do I?
So, we, however, are of the considered view that that aspect of the matter need not be gone into at this stage. And in fact, the petitioners have filed this instant PIL to enable them celebrate the state festival with rituals,
With rituals.
which has already happened. Full stop. It would be open for the parties to agitate the matter
Yes.
should a situation arise in future.
Yes. I think
Stop.
that liberty
The above
will
observation,
suffice.
the PL stands closed.
Deeply obliged.
Oblige, Your Lordship.
Item number 3.
My lord, just one point, my lord, correction at number 2, my lord.
Hmm.
Just word, my lord, that use indigenous and non-indigenous. It's not a case of indigenous and non-indigenous because those who do not perform the ritual also they're indigenous and who perform the ritual that's also indigenous.
we'll
Support
correct it.
But
that part.
may I
That's
submit?
not the indigenous.
Without mincing my words, may I submit? It is basically those who believe on the Christianity faith
But
and
both,
those who have been believing in the traditional indigenous faith, the animism.
but
Both
both sections are
They are
indigenous.
both
my lord.
sections are indigenous.
But that's on.
They're talking, no, he's talking about only the rituals, indigenous rituals. He's
Yes.
not talking about the indigenous.
Because
indigenous
the
you're
other
talking
side
about.
believes in the Christianity faith, therefore they now will not perform these rituals, and therefore they were forcing the minority community. They have become minority in Sagali now, the original ones. So they have been forcing them not to perform the rituals, which happened in the last year. That is why we are before this honorable court. So
All
they
right.
say that they will
We'll
celebrate the
make the
cultural aspect.
necessary rectification, all right?
My lord, my lord.
Rest assured.
I have no dispute regarding that. Let them celebrate their part. We'll celebrate our part. Only that. Oblige, Your Lordship.
Okay. Now, this is also PIL.
Yes, our affidavit is already shown. It's yet to be filed. We'll be filing it in a day or
You
two.
filed it or
No,
the office
It is
reports
already
is not
shown.
filed.
Affidavit has already been shown.
Hmm.
We are yet to file it.
Yes, Mr. Perme, what is this matter?
My lord, issue, my lord, is a, we are against, my lord, is a
Oh, lucky draw,
lucky draw, my lord.
lottery.
Oh, yes, my lord.
Lottery is also held in the state.
Yes, my lord, randomly, my lord. Everywhere, my lord.
Huh?
Lottery, lucky draw, my lord.
Who holds the lottery?
In fact, many organizations, they are holding lottery.
Lottery. The state is still not holding the lottery.
No, my lord.
Officially.
And, yes.
That stopped right now, right?
That's why even we are supporting the case of the petitioner, saying that it is the state who has to hold the lottery. And
But why do you need the support of the petitioner? The state
we have given
needs wisdom and has all the resources
we have given
to enforce
yeah.
law and order and situation like that. Why do you have to bank on some NGO? Anyway, you filed an affidavit.
yes, my lord. Yeah.
Need to file affidavit, my
You are for the
my lord, from respondent number 4 to respondent number 11.
private respondent.
No, my lord.
These are,
The home, my lord, the DGP, SP and all seats, my lord, who has not registered the FIR, man.
4 to 11. Mr. Ratan will be for
1, 2, 3. 1, 2, and 3.
Mr. N. Ratan, learned additional AG, appearing for respondent as 1 to 3, and Mr.
Yes, my lord. Additional.
T. Ate, learned additional AG,
Additional PP, my lord.
additional PP, appearing for respondent numbers 4 to 11. Submits that they need some more time to file the counter affidavit. And they pray for how much time?
For me, my lord, it is 1 week time, shorter 1 week time.
1 week.
A week's
Oh.
time.
Yes.
In view of above, the matter stands adjourned for 10 days. Stop registry to list the matter again on a date to be fixed by it. respondents to file their counter affidavit in the meantime. Mr. L. Perme, learned counsel, appears for the petitioner.
Obliged.
All right.
Item number 4.
Delay.
Yes, my lord. Notice
Who's
was issued,
object-
my lord. Notice was issued, my lord. The service not completed, perhaps, my lord.
Who is respondent number 2? Complainant.
It's a POXO matter, my lord.
POXO matter.
Yes, my lord.
But do you have any objection on the delay?
But I have,
Please write, office note indicates that notice is not yet served on respondent number 2, bracket the complainant. Mr. G. Etel, learned additional PP, submits that he may be given 10 days time to get the up-to-date status. Considering the same, the matter stands adjourned for 10 days to be listed again on the date to be fixed by the registry. Mr.
Entaje.
N. Taje,
Yes.
learned counsel, appears for the appellant.
Yes.
What about, okay, this is only the limitation, I mean, the delay part,
Yes, my lord. If this is done, then again matter will is for admission, my lord.
admission, then
Yes.
PCR and all that.
Yes, yes.
All right,
Obliged, my lord.
that's all for DB. Okay.
May I please allow?
Yes.
My lord,
Sure.
I'm mentioning, I've informed the other side, item number 9 to 13. My lord, in these matters, the petitioner has challenged the registration of the petitioner's entity within the state of Arunachal Pradesh amongst other challenges.
Mhm.
Now, one of the challenge was, my lord, a view was sought to be taken by the revenue that on unsold tickets also we have committed some irregularities. Now, that matter was also taken up by the Directorate of Revenue Intelligence, my lord, where we have got the relief as far as unsold ticket is concerned.
Mhm.
So what we propose to do, my lord, since it is also a subject matter of the present proceeding, we propose to file an affidavit, additional affidavit, bringing on record the order passed by the adjudicating authority. So I pray for some time for that, my lord.
How much time?
I mean, let the matter come after the Bihu vacation, my lord. In the meantime, we will file it.
Any particular date? Since you're coming from Guwahati.
13.
Lordship, in this case, I'm appearing for the CGST.
Hmm.
Lordship, let them bring on what they want to bring.
Hmm.
But state was supposed to file affidavit since August 2025. They have not filed.
State is
Last occasion also, this court has granted 4 weeks time. Lordship, their defense may be closed and the matter may be heard on next day.
Mr. Nabam is there?
Well, let them finish, then I'll address the lordship.
Because Lordship, for
my lord, 20th of April, my lord, Monday.
last more than 8 months, they have not filed any affidavit.
And yes, my lord, states should also file their affidavit.
All right, my lord. My lord, I believe, my lord, if we could file the affidavit on or before 20th April, my lord, both will be happy.
Yes, yes, yes.
My lord, we'll file that, my lord.
Lordship, yes, we file one IA also. That is to be heard on last occasion. This court has observed that we'll hear the matter on the next.
And my lord, since I hearing of the IA and main matter will not make any difference, my lord, let the matter be taken up on 20th April, my lord. In case it spills over, then we can do it on Tuesday also, on 21st.
20th April, that is.
See, lot of variety of cases. One is IA, one is WPC. There's a
No,
criminal.
my lord, there are basically 3 cases, 1 criminal matter and 2, only 3 are writ petition. 1 is writ petition criminal and 2 is writ petition.
You're appealing
Basically,
for
I am for the petitioners in all the cases, my lord.
petitioners,
Yes,
future gaming.
yes, future giving.
And Mr. Kayal is for
He is
the,
for the CGST authority, GST authority, my lord.
2 to 6.
And my learned friend Nabam is for the, my lord, state authority.
okay. Please write down, Mr. K.N. Chaudhary, learned senior counsel, appearing for the writ petitioners, submits that he would like to file an additional affidavit incorporating the order passed by the appellate
My lord, order passed by the adjudicating authority,
adjudicating authority on
27/1/26.
27/1/2026.
Yes.
In view of the fact that the same will have some bearing in the matter, as the decision so taken is also a subject matter before this court.
Yes.
Mr. SC Kayal, Learned Counsel appearing for the CGST,
Not
submits that they have,
We file IA for modification of the earlier entry
Hmm.
order.
interim orders.
that submits that the CGST has filed an interlocutory application seeking vacation of the interim order passed earlier by this court. And therefore, there is some urgency in the matter. Full stop. He also submits that the counter affidavit of the state government also will be necessary in the matter. Stop. Mr. R.H. Nabam, Learned Additional AG, submits that he may be given 3 weeks' time
2 weeks, my lord.
to receive instructions and to file counter affidavit in the matter. Next para. In view of above and as agreed to by the parties, that the matter be listed on 20th of April 2026. The state respondents shall file their counter affidavit on or before that date. Stop. Likewise, the petitioners may also file
File within 10,
additional
2 weeks time,
affidavit incorporating the order passed by the
adjudicating.
adjudicating authority. List accordingly.
Not
My lord, interim orders will continue. my lord.
Liberty may be granted to us if required, we'll file our rejoinder against.
Yes,
the
yes,
affidavit
yes.
filed by the petitioner.
Okay. The parties are also given liberty to file rejoinder to the affidavits filed by the opposite parties, if so advised. Next para, till the next returnable date, the interim order passed shall continue.
Deeply.
All right. 9 to 13. Yes.
Instruction from the state respondent. I beg to mention item number 27.
27.
Finally, this matter may be adjourned for today and fixed on 12th March.
Why do you want adjournment?
Also, my senior, Mr. R. Shekhi, has some personal difficulties.
Okay, Mr. R. Sakia, Learned Counsel for the petitioners is said to have some personal difficulties to conduct the case today on a prayer made on his behalf and not objected to by the other side. Release the matter
12th March.
on 12 March.
May I please, Your Lordship? Your
Yes.
Lordship, I like to PC 530 of 2025 for listing tomorrow, Your Lordship.
Why?
Your Lordship, is a service matter related to transparent posting, Your Lordship. It was listed on 31/2026, Your Lordship.
Pleadings have been exchanged.
Yes, Your Lordship.
You want it listed for what? Orders or admission?
For admission, Your Lordship.
For admission. All right.
May I please, Lordship? Lordship, I beg to mention item number 16.
16.
Yes, Lordship.
Yes.
I'm appearing on behalf of conducting counsel, Mr. T. Gatso.
Hmm.
He's out of station. Lordship, due to some personal difficulties, Lordship.
Okay.
Kindly matter may fix on 12th March.
What about the state who's appearing? Have you informed them?
Yes, Lordship.
This is an arbitration petition.
Yes, Lordship.
Capital Agro Forestry Nursery. You are aware about this, madam?
No.
You are appearing for this state? All right, Mr. T. Gyatso, Learned Counsel for the petitioner, is said to be out of station. And on a prayer made on his behalf and not objected to by the other side, matter stands adjourned to be listed again on 12th of March.
My lord, I beg to mention one unlisted matter, WPC.
Unlisted matter,
Yes, my lord.
what kind of case is that?
My WPC.
WPC, what is the subject matter and what is the urgency?
My lord, the matter was earlier was listed on 17/11/2025. Thereafter, it could be taken up this way, my lord.
Unlisted what? At what stage?
Admission, for admission.
For admission?
Yes, my lord.
Unlisted when? When do you want it?
Within this week.
Within this week?
Yes, my lord.
Pleadings have been exchanged?
Yes, my lord.
Okay, Wednesday then?
Maybe, my lord, then on 11.
Yes,
Yes.
Wednesday is 11 only.
Mm.
Anybody else?
Lordship, Lordship, pending, for release of the salary,
Hmm.
pending matter, this urgency, there is urgency, this matter can this matter maybe take up for tomorrow, Lordship?
Tomorrow will be
Pending.
difficult. Wednesday?
Wednesday.
Wednesday, 11th. Give
And
the date.
yes, another 3 more matters, this is for, we have settled the matter, that
Hmm.
maybe fixed for withdrawal of the matter.
Withdrawal you can have tomorrow?
Yes.
Hmm.
On the same date,
11?
11.
Okay, all right.
Item number 1.
Met PG Lordship, my lord.
Oh. Item 1. Mr. Sharaf, yes,
My lord, the question which is, my lord,
we are on item 1.
one, my lord. My lord, the
Yes,
question which
I
is
think your item is item 2.
item 1 and 2, my lord, both.
1 and, okay, 1 and 2, sorry, yes. 1 also you are there.
My lord. Well, the question which is involved in the petition is that whether the activity of transfer of the hydropower electric power project to the petitioner company by the respondent number 5 is exempt from GST under the notification dated, my lord, 28/6/2017. Lordship, can you see the notification at page 61?
You're taking up, you're submitting in item 1 or 2?
1, my lord, 1. 2 is different, 2 is contempt, my lord.
No, 1 is
Sorry,
contempt.
First is
1 is
contempt.
contempt.
I am sorry, my lord.
1 is contempt case
My lord, this
7
is-
of 2026.
My lord, this is a petition we filed for the willful violation of the court's order dated. You'll also find the order at page, my lord.
Page
It starts
17,
with
page
the-
16,
Page 16.
16.
And the relevant
Oh.
portion you'll also find at page 20, my lord.
Hmm.
Para 12.
Yeah.
Pending further consideration, it is provided that the respondent number 2 shall deduct a sum of rupees so-and-so due to the respondent number 3 from so-and-so, or in the event of no so-and-so is forthcoming, the BG furnished by the respondent number 3 for the amount shall be kept with it till further orders. Now, we communicated the order, my lord, while communication at your lordship on page 21.
Hmm. 21.
This was the communication which was made to the, my lord, to the respondent number 2 about the passing of the order by this honorable court.
Hmm.
But in spite of the order of this honorable court, my lord, the payment has been made by the respondent number 2 to the respondent number 3, and thereby violating the order of this honorable court.
Yeah. How many respondents are there?
One of the respondents in the present case,
There is only one respondent.
one respondent, my lord.
Okay, we'll issue notice then.
My lord.
Heard Dr. A. Sharaf, learned senior counsel, assisted by
Mr. A. Kaushik, my lord. Or anyone local counsel, my lord.
yeah, the local counsel is here.
Email your lordship.
A. Major. Your name is shown anywhere?
No, your lordship, not in the.
You give in writing.
The filing was
Major.
done by the local.
Oh. for the petitioner who submits that the order dated 30/5/2025 passed by this court in WPC number 230 of 2025 has not been complied with the respondent, despite a copy of the same having been furnished to him. Next para, issue notice returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondent by speed post within 3 days. List again after 4 weeks. All right.
Item number 2.
My lord, in this case,
Yes.
my lord, the question which
Yes.
is for consideration, my lord, I
Mm.
formulated page 12, my lord,
12.
12, my lord.
Okay.
The first question, my lord, whether the
Mm.
activity of transfer of the hydroelectric power project to the petitioner company by the respondent number 5 is exempt from GST under serial number so-and-so of notification dated so-and-so. Now, the notification you also find at page 61.
Yes.
You also may see number 2, chapter 9, service by way of transfer of a going concern as a whole or as an independent part thereof. This is exempted, my lord. Now, what happened in the present case, my lord? A hydropower project, my lord, was allotted to the respondent company, my lord, by the government of India, and an MOU was executed between the same. But later on, my lord, the government of India found that the project was not going on in the required pace, and to revive the middle of the state project, the government of India decided that the same shall be executed by the public sector undertaking, and accordingly, the said project was transferred to the petitioner company, my lord. And the petitioner company accordingly paid an amount of rupees 39.89 crores to the respondent company. Now, it was a concern project itself which was transferred from the respondent company to the petitioner company, and thereby it was exempted under the notification. Now, the advanced ruling authority has taken the view that no, it was not a transfer of the entire business, but a project. Now, if you also looks into the definition of the business in the CGST, my lord, CGST Act, my lord, if you also the book is there, or a
CGST Act, we have direct.
Mr. Kayal he must be sitting there.
Mr. Kayal has.
That's it. The definition of business is section 217, my lord.
217.
My lord.
Dr. Sharaf, section number?
Section 2, subsection 17, my lord.
Oh. Section 2, subsection 17.
My lord.
Okay. I heard 217. That's why I could not find any 217.
I'm sorry, my lord.
Both. No, business.
Business.
Definition
Now,
of business, yes.
Right, my lord. Business includes, so it is an inclusive definition, my lord. And you also may see clause C, my lord.
Clause C. Yes.
Any activity or transaction in the nature of subclause A, whether or not there is a volume, frequency, continuation, regularity, or transaction. Thereafter, you also may see, my lord, D, supply or acquisition of goods, including capital goods and services, in connection with commencement or closure of business. So, my lord, the acquisition of any business with activities, whether with the commencement or closure, will come within the purview of the business. Now, the project was undertaken by the respondent, private respondent, on the allotment being given by the Government of India. They started the project, but since the project was not going on, the entire project was transferred to the petitioner company. Now, it was a transfer of the business from the going concern to the petitioner company. Business does not mean that the entire business, like Reliance company, if we say that a business has to be transferred, it does not mean the Reliance company itself, the entire Reliance company has to be transferred. That is not the concept, my lord. And there are various the judgments of the apex court also. I've given the copy, my lord. If your lordship kindly looks into, my lord, 2006 1 SCC, page 615, the local council, my lord. It was sent to the local council, my lord.
The citation?
2006 1 SCC 615.
Yes. Which para?
If lordship looks into paragraph 15 and skip over the next page, my lord. Business at the top at page 622, my lord.
Page?
Page 622.
622.
At the top, my lord. Merit. Business is an activity. Has your lordship got it, my lord? First line.
Business. Yes, yes.
Business is an activity directed with a certain purpose, more often towards producing income or profit. Ownership of assets is merely an incident rather than a characteristic of the business. Hence, the mere transfer of one or more species of assets does not necessarily bring about the transfer of the ownership of the business. For ownership of the business is much wider than the mere ownership of discrete or individual assets. In fact, ownership of business is wider than the sum of the ownership of the business constituting assets. After all, transfer of the ownership business requires that the business be sold as a going concern. In our view, therefore, Section 15(1) is intended to operate only when there is complete transfer of the ownership business so as to render the transferee a success in interest of transferee. Only in such an eventuality, the Section 15(1) transferee is liable to transfer sales tax activities. So it defines below where the transfer of the ownership of the business. Now, we'll also kindly see, my lord, the decision of the Andhra Pradesh High Court in 2026 SCC Online 258. Para, my lord, 16.
What is the citation?
2026 SCC Online, Andhra Pradesh 258.
Yes, which paragraph?
Para 16, my lord.
16.
16, my lord. I read from the ratio set down in these judgments would apply to the provisions of the GST Act, as the language in these provisions is similar to the language of the provisions in the Sales Tax Act and the Value Tax Act. The aforesaid judgments make it clear that it is only sales which are in course of the furtherance of business and not sale of the business itself which can be taken under the provisions of the GST Act. In the present case, there was a transfer of the entire R&D unit as a going concern, including the assets and liability. Such a transaction would be a sale of the business itself and not sale and supply of the individual goods. So, my lord, when the entire project, along with the all assets, asset activities was transferred, it was a transfer of the business and it was exempted from the payment of the GST. Now, the advanced ruling authority, my lord, has held now that it is not a transfer of the business in the meaning of the notification which has been issued by the authorities, and thereby it is not exempted. We filed an appeal, and the appeal was also the applicant filed an appeal, and that was also rejected, and thereby we have preferred the budget application, my lord. In my Mr. Lord, this is a fit case for examination by your lordship, my lord. Because after all, the tax burden will be on the petitioner because the petitioner is acquired. So tax has to be paid, will be collected from the petitioner, my lord. So your lordship may kindly be pleased to, my lord, examine the matter.
Where is the that impugned order?
Impugned order,
7925?
well, your lordship will find the impugned order. The first order you'll also find at page 165. That is the advanced ruling authority, my lord.
Yes.
And the conclusion part, my lord, you'll also find at page 197. Para 5.19, my lord.
Yes.
My lord. Therefore, in terms of the MOU dated so-and-so, it is apparent that it called transfer of the project as claimed by the, that's so called transfer of the project as claimed by the appellant to NEPCO against the payment of previous code is actually the two cents, a reimbursement from the third party, NIPCO, in connection with the initial expenditures incurred on preparatory works such as the techno feasibility study, preparations of the DPR, clearances, etc. for the said project without any physical assets. Thus, in view of the aforesaid, we are of the considered view that when the development works of the project has not been started, but just at the stage of preparatory work, such as the techno feasibility study, preparation of the CRC, clearance, project, and so and so, the same will not be business activity. Now, business activity, as I have shown to your lordship, in the definition, the commencement or the closure, both are included. Now, the authority has taken the view that no, the preparatory works were going on, and there was no transfer of the assets. The transfer of the assets is not a precondition for the business. Business is not doesn't mean that the assets must be there. A project was there, and it was a business as per the definition of the business which has been given under the GST Act. So to say that there was no assets and preparatory works were going on, that is not correct, because the hydropower project itself was transferred from the respondent to the petitioner, and thereby it was a transfer of the business as defined in section 217 of the GST Act. We filed an appeal, my lord, and the appeal was also dismissed. The applicant filed an appeal, and that was also dismissed. It starts at page 200. And the relevant portion at 245, the same conclusion has been taken below. Para 6.22.
Which page?
Page 245.
Six
6.22. Well, the same view which was taken by the earlier authority has been taken by the appellate authority, which is quite contrary to the definition of the business as well as the decisions which I relied on before lordship. This is not correct at all, that the authority has taken the view that the assets must be there. Well, the business does not mean that the assets has to be there, because it says at the commencement of or closure of. So commencement, when we say, my lord, that it cannot be said that the assets must be there. A project was there and the project was transferred. That was a business.
Dr. Sharaf, you have not challenged this advance ruling dated 11/4/25.
My lord, because it was an appeal, my lord, and the appeal which is there, then it merges with the appeal, my lord, because the appellate authority, the appeal was preferred
Okay.
before the appellate authority, so it merges with the appellate authority.
It merges with that, that's why, okay.
My lord, my lord.
Yes, Mr. Kaya,
Lordship, I am appearing for respondent number 3.
okay.
Lordship, here appeal lies under section 101A, capital A.
101 capital A of the CGST Act.
Lordship,
Is there an appeal here?
appeal was filed under section
Before whom?
108
Appeal lies before whom?
before the National Appellate Authority,
Okay,
section 101A, capital A,
okay. Against the order passed by the
Appellate Authority, Lordship.
appellate authority passes the order under what?
Lordship, under section 100,
100 bracket 1,
100, Lordship, yes,
100.
100.
Are you challenging on the maintainability?
Yes, Lordship.
You're raising that issue.
Lordship. Regarding merit,
Well,
Lordship, I
I-
required some time to address.
But as you lost aware, my lord, that recently the apex court judgment in Godra Sarali, wherein the apex court said, my lord, when the question of law is there, then the writ petition will be maintainable and the writ petition should not be thrown out on the ground of the alternative remedy. Now here, my lord, the question is absolutely on the interpretation of the notification of exemption which has been granted. What is the interpretation of? That's why I posed, my lord, the question which was there, and that is pure question of law. And the pure question of law, my lord, and the factual, there is no dispute at all. So factually dispute is not there, then the lawsuit is aware that the question is maintainable, and alternative remedy does not mean that the court will not entertain the writ petition in all the cases. The writ petition only when the factual disputes are there and disputed questions of facts are there, the appeal will not be, the court refuses to entertain the writ petition. But the recent and all other judgments are there, that whether the three circumstances when the jurisdiction is not there, when it is exempted, then how the authority can say that it is taxable? The jurisdiction at all is not there to levy the tax. Your lordship may admit, and if my learned friend, my lord, for satisfaction, your lordship may keep the maintainability question open if he wants to, my lord, agitate the subsequent instance.
Of course, they'll be at liberty to raise that.
Lordship, that is correct, but Lordship, here, both the authorities just consider all aspects of the matter, Lordship. And Lordship, our High Court in different judgment has held that when statutory alternative remedy is there, the petitioner has to exhaust that. And Lordship, regarding question of jurisdiction, Lordship, they file advance ruling before the authority, Lordship. So now they say that they have no jurisdiction and they travel beyond the jurisdiction of the authority, Lordship.
All right, we'll leave that question open.
That's why
At this stage, we'll just issue notice. We'll keep the question open. You may file your response to that.
Otherwise, my lord, where the question of appeal, my learned friend said they have gone in the advance ruling. If going in the advance ruling is final, then where is the question of appeal? That is final. Nobody can touch it. My learned friend is saying, my lord, that once you have gone in advance ruling, that is final.
All right. Hot Dr. Sharaf, learned senior counsel, assisted by A. Menjo. E. Menjo for the petitioner, who submits that by filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 7/9/2025 passed by the appellate authority for advance ruling bracket annexure Roman 9,
Roman 10.
which was
Roman 10, page 200.
no, it's Roman 9. The initial part, the initial advance ruling then
Initial,
was
my lord.
upheld.
I'm sorry.
Roman 9, which was subsequently upheld by the appellate authority by
Page 200.
the order dated 7/9/2025. Bracket annexure Roman 10.
But the main question is page 12, which I formulated, my lord. Question number 1, my lord.
Next para, the learned senior counsel submits that the question to be addressed and considered in the present petition is as to whether the activity of transfer of Tato Roman 2 hydroelectric power project to the petitioner company by the respondent number 5 is exempted from GST under serial number 2, notification number 12/2017 dash central tax bracket rate dated 28/6/2017. Page
This is
12,
the only
in
question.
various page 12. The learned senior counsel also submits that the impugn orders passed by the appellate authority are contrary to the statutory definition of within inverted comma business close inverted comma under section 2 bracket 17 of the Central Goods and Services Tax Act, 2017. Gustav, he submits that the authorities erred in treating the transaction as mere transfer of preparatory works and reimbursement of expenses rather than transfer of an independent undertaking capable of being carried forward. The learned senior counsel, in support of his submission, has relied upon the following authorities. Number 1, State of Karnataka and another versus Priya's Papers, bracket P Limited and others, 2006, 1 SEC 615. And number 2, Shilpa Medicare Limited and others versus Union of India and others. Rendered by the High Court of Andhra Pradesh and reported in 2026 SEC Online AP 258. Of the learned counsel, the learned senior counsel also submits that although there may be a statutory appeal provided, But since there are questions of law involved, this court is empowered to entertain the same in exercise of its jurisdiction. Next para. At this stage, Mr. SCKL, Learned Counsel, Learned Standing Counsel, CGST,
For respondent number 3,
appearing for respondent number 3. Who is that respondent number 3?
Appellate Authority.
Appellate Authority. Submits that there is clearly a provision for filing an appeal under section 101A, capital A, huh?
Lord, sir.
Before the
National Appellate Authority for Advance Ruling.
National Appellate Authority for Advance Ruling.
Ruling.
And therefore, on that count, the instant writ petition should not be entertained. Next para, in view of above, let the notice be issued, returnable by 4 weeks. Who appears for 1 and 2? Mr. M. Kato, Learned DSGI, accepts notice on behalf of respondent numbers. Respondent number 1. And number 2?
Also, I'll be for 2 and 4.
Miss Giete. Correct? You are Giete.
Yes.
Learned Senior Government Advocate?
Additional
Senior Government Advocate accepts notice on behalf of respondent number 2. And
2 and
Mr.
4 also.
Okay, 2 and 4.
Yes.
Mr. SCKL, Learned Standing Counsel, CGST accepts notice on behalf of respondent number 3. Petitioner to take steps for service of notice upon the respondent number 5 by speed post within 3 working days. Extra copies of the writ petition be furnished to the learned counsels for the respondents appearing today within 2 days. This is the matter again after 4 weeks. Maintainability of the writ petition is being kept open. Respondents may file their response to the same, to the writ petition in the meantime, if so advised. Yes?
Well, page 27, my interim prayer is there.
What is your interim prayer? Okay. Next para, having regard to the projection made by the petitioner, it is provided herein that the respondent authorities concerned shall not take any coercive steps pursuant to the order passed on 7/9/2025. Bracket annexure 10. List again on so and so.
20th of April.
List again on 20th of April.
We want to go, but come on the same day and do all the cases. He should be asked for different dates, my lord. I'm obliged. My lord. I'm obliged.
Much obliged.
Item number 3.
Should be a shortcut from your table, huh? To come all the way around.
Your Lordship, this is a writ petition where the petitioner has been elected during the Panchayat election 2024, and she has been elected as the DPC from the Kramna Tanda constituency. Accordingly, I have the copy of certificate of election I have annexed in the page number 16 and 17. And thereafter, On 10 January 2026, the petitioner has been elected as Gram Panchayat chairperson, Your Honor. And thereafter, on 10 January itself, the district president, BJP, that is Anjaw district, Your Honor, has lodged a complaint before the member secretary for disqualification of the elected chairperson, Your Honor. And stating that the petitioner has violated the party whip, which was issued on dated 3 January 2026.
Which is the order you're challenging?
Your Lordship, I'm challenging the order dated 6 February 2026.
Which is at page
Page number 24, Your Honor.
24.
Yes.
Yes, who is the petitioner?
Your Honor, petitioner is the elected Gram Panchayat, Your Honor.
Elected Gram Panchayat.
Yes, from the Tamna constituency, or from the Tamna constituency. And Your Honor, the petitioner has never issued a so cause notice, Your Honor, by this Deputy Commissioner, Your Honor. Only on the basis of the expulsion order, which is 10 January 2026. I have annexed in that and page number 20, Your Honor. Basing on that, relying on that only, the DCS taken steps, Your Honor.
What is the remedy after being disqualified from membership of Gram Panchayat?
Your Honor, as per the BJP bylaws, Your Honor, I have annexed in as election 9 in page number 29 and 51, Your Honor. Here, Your Honor, I will read the operating part, Your Honor, the relevant part.
You are referring to the constitution of a particular party,
Yes, Your Honor.
correct?
Yes, BJP bylaws, Your Honor. And also, Your Honor, I'm referring the principle of natural justice, Your Honor. Here, the petitioner had never been so caused by the Deputy Commissioner for explanation, Your Honor. And also from the
Action has been taken against you under the provisions of the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2003,
yes, Your Honor.
read with the amendment of 2006. So why do you take me to the constitution of a particular party?
Your Honor, the DCS relied on the expulsion order on your culminating the
Where?
the order, Your Honor. Page number 24, Your Honor.
You have abstained from some meeting, first meeting.
No, Your Honor.
Is that the reason why?
No, Your Honor. Actually, Your Honor, in this case, the petitioner is set up by the BJP party, Your Honor. And
No, simple thing is, why have you been disqualified? What is the reason?
the ground for disqualification is that he is absent from being.
You have abstained from attending the first meeting or from voting and all that. This is the,
Yes, yes.
this is what is provided.
Yes.
Party whip. Incurred disqualification at 3(1)(b) of the yes,
This is a notice may be issued, Lordship.
notice.
Because the imperial order was passed on, Lordship, 6th of February. 1 month has already passed.
So what is the remedy otherwise after being
Otherwise,
disqualified?
under this act, Lordship, that appellate provision is not given. Lordship.
Not
If
there.
Lordship see the page 25, Lordship.
Hmm.
The act is Arunachal Pradesh Local Authorities Prohibitions of Defection Act 2010.
There's no remedy,
There's no remedy, Lordship.
appeal or something like that, revision, review.
Rather, if Lordship see the section 7, it bars the Lordship, no court shall have any jurisdictions in respect of matter connected with disqualifications of member of this act, Lordship.
That's why.
Rather, that bar is there, Lordship.
You know, I've annexed this annexure. I've annexed in annexure A, Your Honor. The Arunachal Pradesh Local Authorities Provision Repection Act 2006, Your Honor. The page number 28, Your Honor. Here, the state election commissioner has been deputy commissioner. Here, the election commissioner has substituted in deputy commissioner, Your Honor. And my submission is that after receive a complaint by the member secretary, the member secretary is supposed to forward the application before 24 hours, Your Honor. But here,
Member Secretary of?
member secretary, Your Honor,
Which member secretary?
of the concerned local authority, Your Honor. But here in this case, the member secretary forwarded the application on 12 Your Honor. 12 January 2026. It is after expiry of 2026. My submission is that, Your Honor, even if disqualification must be taken, but the petitioner could have been given the suppose, Your Honor, for explanation.
Okay, we'll issue notice, all right, at this stage. Right, Mr.
Your Honor, till the interim maybe.
We'll issue notice on the interim. That's all. Art, Mr.
K. Time, Your Honor.
K.
K. Time.
Tying,
Yes.
learned counsel for the petitioner who submits that by filing this writ petition, the petitioner has challenged the order dated 6/2/2026. Bracket. Annexure 6,
Yes.
by which the petitioner has been disqualified from the membership of Gram Panchayat How many petitioners are there?
One petition.
Concerned in exercise of the powers conferred by Section 6(2) of the Arunachal Pradesh Local Authorities, open bracket, prohibition of defection, close bracket, Act, 2003, and its amendment in the year 2006 by the Deputy Commissioner, Anjar District. The learned counsel submits that the impugn order has been issued without giving any opportunity to the petitioner to defend himself by issuance of a show cause notice. The learned counsel therefore submits that the impugn order dated 6/2/2026 should be set aside. Next para, in view of above, issue notice, motion returnable by 3 weeks. Mr.
Yes, Tapin notes.
S. Tapin, learned senior government advocate, accepts notice on behalf of
1 and 2.
respondent numbers 1 and 3.
1 and 3.
Petitioner to serve requisite copies of the writ petition to the learned senior government advocate within 2 days. We'll stop. petitioner to take steps for service of notice on respondent number 2 by speed post within 3 working days. Next para, also issue notice on the interim prayer, turnable by 3 weeks as well. Learned State Council shall obtain instructions by the next date. List again on so and so. Give a date after 3 weeks.
It is fifth. Fifth.
Today is 9th, isn't it?
Then on 2nd of April.
2nd of April? Okay.
Yes, sir.
Item number 4.
If it may please allot.
Just a minute. Yes.
My lord, the petitioners are the senior most in the cadre of inspector, telecom and radio technician in the civil police in the Arunachal Pradesh Police Department, Your Lordship. However, the petitioners are aggrieved by the action of the respondent authorities by not conducting DPC, despite they being eligible for further to be considered for further promotion to the post of Deputy Superintendent of Police, Your Lordship.
There are more than one petitioners.
Yes, Your Lordship, 5 of them.
What are they, petitioners?
They are currently they are serving as the inspector in the telecom
Inspector,
and radio technician in civil police, Your Lordship.
Inspector,
Telecom and radio technician.
telecom and radio technician. Radio and telecommunication.
Yes, Your Lordship.
You are governed by any particular rule?
Yes, Your Lordship.
Where is that?
At page number, I'm sorry, Your Lordship. At page number 26, that is inspector, that is for inspector telecommunication, annexure 1.
What is this rule?
The rules,
The Inspector Telecommunication Group C Recruitment Rules 1988.
yes,
Okay. You are appointed under this rules.
yes, Your Lordship.
Okay.
And there's another rule, Your Lordship, at page number 37.
37.
This is inspector of police, radio technician in Arunachal Police Telecommunication Rules.
This is also inspector only.
Yes, Your Lordship.
What is the difference?
There's no difference, Your Lordship, except for the fact that one of them chooses to be inspector in the cadre of inspector telecommunication and other chooses to be in inspector inspector radio technician, Your Lordship.
Radio technician.
Yes, Your Lordship. And one of them
One is telecommunication.
telecommunication.
Radio technician. Okay. So 1988 rules and 1999 rules.
Yes, Your Lordship.
Petitioners are appointed under these two rules.
Yes, Your Lordship.
So their post can be interchanged.
No, Your Lordship, since they chooses to be in the line of telecommunication, they have to go through that line, and the other person, if he particularly chooses to be in the line of radio technician, that is how the further promotions are to be made to the further higher post of Deputy Superintendent of Police, Your Lordship.
See, both the inspectors of radio technician and inspectors of telecommunication are eligible to be considered for further promotion.
To the post of Deputy Commissioner.
DSP,
Yeah,
Deputy Commissioner,
no, sorry, Deputy
DSP.
Superintendent of Police,
DSP,
Telecommunication, Your Lordship.
telecommunication, which is governed by what rule?
It is at page number 47, Your Lordship, page annexure 3.
47.
The type copy will be at page number 51.
So this rule is only one particular post.
Yes, Your Lordship.
Earlier rule was for inspector. This is for DSP only.
Yes, yes.
Now, where's the relevant portion?
Relevant portion will be at page number
Annexure.
Annexure 3. page
Annexure
number
B.
3. Annexure 3. Page number 57 of the type copy.
Oh, type copy. I prefer the original one. Let's see.
That will be at page number, relevant portion will be at page number 49, Your Lordship,
49. Column number
11 and 12.
11 and 12. 50% promotion, 50% direct recruitment.
Yes, Your Lordship.
And then
50, and at column number 12, 50% by promotion amongst the inspector of telecommunication, radio technician with 3 years regular service in the grade or transfer or and deputation officer under central or state police, holding the analogous post for regular service of 3 years.
But where have you have not enclosed the entire thing? You started enclosing it from column number 9. Column number 1 to 8 is missing.
No, Your Lordship, that will be at page number, I'm sorry, but that is at page number 50.
50.
Yes, Your Lordship.
Oh, that has come before that. Okay.
Yes.
GSP Telecom. Number of posts is 1. Only 1 post.
No, Your Lordship. Currently, there are 2 vacancies. The number of posts were increased to 5 numbers in the year 2012, Your Lordship.
5.
Yes, Your Lordship.
Okay. Currently, there are how many vacancies?
2 vacancies, Your Lordship.
And how it is to be filled up? It is through this 50% by promotion, 50% by direct recruitment.
Yes, Your Lordship.
There are 5 posts. How do you divide 5 posts into 2? Not possible, isn't it?
My Lord, the post meant for direct recruits were filled, Your Lordship, and there are now 2 vacancies meant for promotion quota, Your Lordship.
Okay.
And that is why the petitioners are here, Your Lordship, since they are.
You need to have 3 years
Yes, Your Lordship.
of service. Any other requirement?
No, Your Lordship. 3 years of regular service.
If you have 3 years of regular services in the grade of inspector, you can be considered for promotion.
Yes, Your Lordship.
And when did the vacancy occur?
Vacancy occurred in the year 2023, August.
So that it's not being filled up. That's
No,
why you're here.
Yes, Your Lordship.
Any representation you have filed?
Yes, Your Lordship. Yes, at annexure 13, Your Lordship.
13. 13 series.
10.
Any reply to your representation?
No, Your Lordship.
July 25.
Yes, Your Lordship.
Okay. Ms. Pangu, what do you say?
Your Lordship, in this state, Your Lordship, notice may be issued, Your Lordship.
Will issue
I need to get
notice,
instruction, Your
but
Lordship.
why you're not filling up the post?
For this, I need to take instruction, Your Lordship.
You have not taken advance instructions. You believe in post instructions, not pre instructions. Eh? Okay. Heart Miss
D. Tamuk.
Tamuk. D. Tamuk, Learned Counsel for the petitioners who submits that the petitioners are currently serving as inspector bracket telecommunication and inspector
Radio technician.
bracket radio technician. Under the state government in the police department. She submits that the petitioners having the requisite number of years of service in their present grade are eligible to be promoted to the post of Deputy Superintendent of Police, bracket Telecom, which is a Group A post. Gazetted and non-ministerial. Under the provisions of the Deputy Superintendent of Police, bracket Telecom, bracket Group A Gazetted, close bracket, non-ministerial, comma, Recruitment Rules 2010. Stop. The Learned Council submits that there are 5 sanctioned posts of Deputy Superintendent of Police, Telecom. And there is, and that out of the 5 posts, 2 posts are vacant since the month of August 2023. Stop. The said vacancies are meant for promotion. The said vacancies are to be filled up by way of promotion in terms of the relevant rules. Stop. However, despite the same, and despite the petitioners having represented to the respondent authorities concerned, as the posts are not being filled up, they are before this court through the instant writ petition. Next, para in view of above, issue notice of motion returnable by 4 weeks. Ms. P. Pangu, learned government advocate,
For all the respondent, Your Lordship.
accepts notice on behalf of all the respondents. Stop. Notice is therefore complete. Petitioners to serve requisite copies of the writ petition to the learned government advocate within 2 days. This is the matter again. After 4 weeks on a date to be fixed by the registry. Stop. Pendency of the writ petition shall not be a bar for the respondents to mitigate the grievance of the petition.
My lord, there's a small correction, Your Lordship. Earlier, there was 1 post of DSP, Your Lordship, and it was increased, and 5 new additional posts were created in the year 2012, Your Lordship. And now there are total number of 6 posts. 3 meant for direct recruits and 3 meant for promotional.
5 will be turned into 6, okay. So I'll just rise for a while and come back.
Item number 5.
Yes.
My lord, the petitioner, my lord, who was earlier appointed as the legal law officer come legal advisor of the Itanagar Municipal Corporation, my lord, is agreed by the decision of the respondent authorities. It meant doing away with the post altogether, my lord. My lord, that was on malafide intention, my lord. I will show if your lordship.
Post was abolished.
Post was abolished. Could not have been, my lord. It's a statutory requirement, my lord. It's a statutory requirement. Why this has been abolished is because there was a requirement, my lord. The election has been just been held. There are 3 standing committees in terms of section 57. These are, my lord, financial committees and all.
Now with the impugn order.
Impugn order is first the notification. If your lordship may kindly have the act for a moment first, my lord, at page 35. I've only annexed the relevant portions. I have the act with me, my lord. It's very voluminous. It's kindly at page 38, my lord.
Yes.
Section 73, my lord, subsection 3. My lord, kindly see the language used. There shall be a legal advisor, come law officer to aid and advise the corporation in all legal matters to be appointed by the corporation on such terms and conditions as may be prescribed. And subsequently it says after 2 years joint commissioner and after 5 years it should be a deputy commissioner, something like that. So the word is shall be. So it's a mandate, my lord.
What is this act? Arunachal Pradesh Municipal Corporation Act 2019.
Yes.
how it has been abolished?
My lord, I will kindly see, when, if your lordship.
By
will
way of
ki-
amendment?
No, my lord. That's
How?
why, my lord.
How?
Your lordship will kindly see at page 94. Before that, I just wanted to point out, my lord, why they have done it. If your lordship kindly have page 39 for a moment, my lord. Just before that.
39.
57. Yes. The corporation shall have the following standing committees: General Functions Committee, Finance, Contract and Planning Committee, and Social Justice Committee. Now, the members of this committee, you will kindly see at page, subclause 2, subsection 2. Each standing committee shall consist of not less than 3 and not more than 5 councillors, including the mayor or deputy mayor, as the case may be, elected by the councillors of the municipal corporation from amongst the elected councillors. So there has to be an election. This was not done. The mayor handpicked the candidates. I, being the law officer, objected to it. That is why it has been done. The notification MP note at page 94. Serial number 3.
Yes.
The members present, while reviewing the status of existing manpower of IMC, observed that some of the posts in IMC approved due to exigency earlier, and the monthly remuneration of such approval are borne by the IMC's own revenue source, are not actually required on that. Now, how can they say that, my lord? It's a statutory mandate. Therefore, to ease the financial burden on IMC exchequer and actual manpower requirement of IMC, the present scenario, the post of legal advisor such and such, to be discontinued. This is dated 27th of February. I received the memo notice on 5th of March, on Friday, at page 96. So this is the ground, my lord. This can't be a ground, my lord, knows when the statute prescribes a thing to be done in a particular manner, it has to be done in that manner only, and in no other manner. It's a statutory mandate. There has to be a post of law officer come legal advisor. They cannot say that because of manpower requirement, there are more manpower, so I will do away with this post. It's like saying, my lord, the state will do away with the post of the Advocate General. It's a constitutional post. This also is a statutory post, my lord.
Under Article
My lord,
165.
yes. It's akin to saying that, my lord. I'm praying for notice that this is a private facie, my lord, legal, but I'm praying for stay, my lord.
Heard Mr. D. Pangin, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the notification dated 27/2/2026, bracket annexus 17,
Yeah.
as well as
The notice.
the notice dated 5/3/2026,
Well.
bracket annexure 18,
Yes.
by which the post of legal advisor come law officer in the Itanagar Municipal Corporation
My lord.
has been done away with. Others with effect from 27/2/2026. Now, the learned counsel referring to section,
73(3) at page 38.
I've got it, Mr. I've got it. Referring to section 73, bracket 3 of the Arunachal Pradesh Municipal Corporation Act, 2019, submits that the post in question has been mandated the Act, and therefore it cannot be abolished. In the manner it has been done, by way of a meeting held in a general function committee of the Itanagar Municipal Corporation. The learned counsel submits that the impugn action of the respondents concerned appears to be only for certain ulterior motive. And not otherwise. So he submits that it is a settled principle in law. If a certain thing has to be done in a certain manner, and for which provisions are provided, the same cannot be done in any other manner, except in accordance with what has been provided. Stop. He therefore submits that the impugn notification and the notice should be set aside. Stop. Further pending disposal of the writ petition, learned counsel prays for an interim order. Of stay of the impugn notification and the notice. Next para, in view of above, issue notice of motion returnable by 4 weeks. Who will be appearing? This is municipal, isn't it?
Yes, well, there was a standing council, but he also have been removed, my lord. Standing council, my lord, I can understand. By the same notification, in fact. We'll take steps.
Returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondents by speed post within 3 working days. Having regard to the projection made, it is provided herein that till the next returnable date, the impugn notification dated 27/2/2026, as well as the impugn notice dated 5/3/2026 shall remain stayed. Stop. Since the interim order has been passed in the absence of the respondents, the respondents would be at liberty to seek for alteration, modification, and vacation of the interim order. If so advised. List again on so and so. We'll give a date. 4 weeks, I said, isn't it? Today is what, 9th, isn't it?
Then
on 6th of April.
Yes.
Yes.
Item number 6.
My lord may say in respect of the petitioner, because others have also been removed by that, by the notification.
Correct, you're right. In the interim, I said, the impugn notification dated so and notice dated shall
Only the
remain stayed.
notification, ma'am. The notice is in respect of you. The notification is in terms of others also.
Shall remain stayed in so far as the writ petition is concerned.
My lord, this case, my lord, is all reading completed, my lord, is ready for hearing, my lord. Now, my lord.
So are you ready?
My lord.
Or you are jail sing? That was a anyway.
My lord, this is a case, my lord, wherein initial my entry is as per by through competitive examination selection process, and entry of the private response number is utter illegality in violation without any semblance of selection process. They're backdoor entry, my lord.
Backdoor entry to which post?
to the post of SK, supervisor in Kanungo, my lord. Initial appointment, supervisor in Kanungo, SK, in the short SK.
What is that? Supervisor in Kanungo?
Supervisor Kanungo, my lord. It's a department blended survey staff.
We call it as a, in Assamese, we call it as a mandal,
Mandal.
who go and surveys the land, prepare the map for land allotment.
Surveyor.
A surveyor, kind of surveyor.
Supervisor Kanungo.
It's typical, the Assamese word has been employed in this.
SK and Mandal is different.
Where is that?
SK Mandal, my lord.
Where is it given? Just show me. Any rules, anything like that?
Yes, it's my dear, my lord. I'll come to the detail. Just on gist, I'll highlight, my lord, the fact of the case gist.
No,
Now,
I understand.
yes,
I just wanted to see that particular post. I
my
think
lord,
that
page,
annexure 1.
page 50, my lord, you see.
50 annexure 1, Supervisor Kanungo.
Yes, my lord.
Okay. You governed by this 1986 rules.
Yes, madam. Subsequently, that has been superseded by new act, madam, new recruitment rule in 2008, my lord.
2008 is the latest.
Yes, my lord.
So we are concerned with the 2008 rules.
Since I'm challenging their appointment as well, initial appointment when this 1986 was enforced, that no selection process was done, madam. I'm challenging that part. That also, madam, that's relevant. And
so 86 also is relevant.
Yes, my lord.
Apart from 2008, 1986 rules is also relevant.
Yes, my lord.
Okay.
Now, I've been appointed as a supervisor in Kanungo through a selection process, my lord. And after serving, my lord, certain years, my lord, on merit, I was given promotion to the post of next level, my lord, assistant survey and settlement officer, my lord.
No, when
in
did you
year,
enter?
just, I'll just, my lord, I'll just gist, my lord, highlight. In the year 2016, my lord. Thereafter, my lord.
You entered service in 2016?
No, my lord, 2008-9, my lord.
2009. That means after the amended rules.
Yes, my lord. Under amendment rules.
Amendment rules of 2008.
Yes, my lord. Before just enter into the merit, my lord, just detailed case.
Okay, you want to give me a
gist highlight.
All right.
Gist, my lord. 2008-9, under this latest amendment, latest recruitment rule, I was appointed through a selection process. And having appointed in the supervisory corner, having served a certain period, my lord, I have been given promotion. Initially, I was given officiating promotion, and thereafter, my officiating promotion was regularized in year 2016, my lord, on regular basis.
Okay, you entered as what? Supervisor?
Yes, my lord. And next promotion.
Promotion post is?
Assistant survey and settlement officer, my lord. Assistant, my lord.
You entered the service as supervisor.
Yes, my lord.
And thereafter promoted as assistant?
Survey and settlement officer, my lord.
Survey and settlement officer.
Yes, my lord.
24 August
My lord.
2009,
I'll just come to that with
born in the cadre.
I'll just highlight this. I'll just now, my lord. After
so what is the problem then?
My lord, I'll just that is why I'm coming to the crux.
Happy with your promotion?
I'm coming to the crux of the point now. Now, after having served in the post of assistant survey and settlement officer on a regular basis for the last 7 years, my lord, they have conducted a DPC for promotion to the next post, that is DLASO, District Land Revenue and Settlement Officer. And it was conducted in 2022, my lord. And my name was recommended as a serial number 1. And after keeping the file, recommendation after keeping the file for 8 months, later on they put up the file for review, and according to my recommendation was turned down. And the recommendation was made in favor of the private respondent who is illegal infringement. Looking, without considering all those aspects, the promotion to the post of the recommendation has been turned down. Not only that, my lord, even my earlier promotion to the post of assistant survey and settlement officer in the last, which was done 2016, that was also sought to be reverted back without giving even single notice, my lord. That's I'm agreed by this order, this 2 order, my lord, I'm challenging, and there's an interim order, my lord. This is how, my lord, this come off, my lord.
What is the interim order?
My lord, not to give effect to those recommendation, my lord, because I've been reverted back, my lord. I've been sought to be reverted back, recommended, and that has been stated, my lord. Now, my lord, coming to the case, my lord, detail now, my lord. Now, as per 1986 recruitment rule, my lord. Page 56, my lord. Type 52, 57. Now relevant page 56, my lord.
Your entry was surveyor.
Yes,
supervisor.
surveyor, my lord.
Supervisor.
Supervisor Kanungo.
Okay.
SK, in the short SK. Now, this SK, my lord, it is the type copy 54 and the relevant 56, my lord, I'll just highlight 56. Okay. 56, my lord.
Type copy.
Yes, type 56, my lord. 56, name of post supervisor Kanungo. So my lord will see column 5. Selection for direct the selection post for direct recruitment, my lord. In case of direct recruitment, there's a selection, my lord. That's mentioned, it should be done through a selection process, my lord. And for promotion, my lord, no selection for promotion, subject to that rejection, my lord. Now, under 1986, my lord, the post for promotion, post for appointment to the post of supervisor Kanungo is through selection process, my lord. And there in that act, of course, the educational qualification is matriculation, my lord. Now, my lord, despite of these provisions, without going through selection process, page this private respondent number 4 was illegally appointed, my lord. At page 59, my lord.
When?
Page on 11 June 2023, my lord. 3, my lord. 3.
Respondent number 4.
4, my lord. Illegal appointment. They were illegally appointed to the post of supervisor Kanungo.
What do you say illegal?
Without any advertisement, without any selection process, my lord. On official thing basis, my lord. Page 59, my lord.
59.
And yes.
But the rule says what? What does it say?
Rule says selection process. It should be the appointment should be through selection.
50% by promotion, 50% by direct.
Yes, direct. And direct is selection process, my lord. Now here, 59, my lord, initial appointment of private respondent number 4, without any selection process, my lord, on officiating basis.
Selection post for the recruitment. And who will select?
My lord.
Composition of the selection committee.
My lord.
Direct recruitment is by selection, you said, no?
By the department, yes, my lord.
So is it this column number 12?
Yes, my lord. Through a director, actually. The composition. Approval has to be done by secretary, my lord.
Selection post for the recruitment.
Earlier, land, my lord, Department of Land Management was known as, my lord, land records, my lord. Land record, my lord.
Same, sir. Same. See, one thing, why is it subdivided, this column 5 as A and B?
Column 5, my lord.
This divided as A and B. It correlates to column 10?
Yes, my lord. My lord, you see there, whether selection or non-selection post, my lord. The column 5, my lord. The top, my lord, will see whether selection or non-selection. Now here it is specified that selection post for direct recruitment and non-selection for promotion subject to rejection, my lord. This relates to, my lord, this in case of the 50% for the direct recruitment is a selection process, my lord.
Rota quota reservation, 50-50.
For promotion, who can be promoted to this post?
Madam Mandal, my lord.
Who is that?
Column 11, my lord. Against 50%, my lord. promotion from the amongst the Mandal having at least
3 years.
3 years
Okay.
continuous service in the grade.
Okay. So respondent number 4 is a direct recruit.
Yes, illegally.
Can we see 10 also, column 10 in this? That the 50 fees divided total. Page 57.
Let's malware already seen 50% direct recruitment, 50% promotion.
Okay, please proceed.
Yeah. Now, thereafter, malware see phase 59. It's a type copy of the appointment, initial appointment of the private respondent number 4, malware. Without any selection process, was appointed to the post of
Officiating basis.
yes, malware. Without any semblance of selection process, malware. Thereafter, malware, again, the private respondent 5, page 61, malware, was again in similar manner. It was appointed. It was appointed on 27 February 2004 at page 61, malware, initial appointment. You can see here appointed supervisor purely.
Who is he?
My lord.
Who is he?
He's respondent number 5, my lord.
Okay, there
Private
are two,
respondent.
There are 2 private respondents.
Yes, my lord.
Okay.
Now, these 2 illegal
Yes.
my lord, these 2 illegal appointees, my lord, they were regularized, my lord, in year 2005 at page 63, my lord. See the type copy with reference to the the officiating appointment under survey and service from regularized with effect from my lord. Now, serial number 3 is respondent number 4, and 4 is respondent 5, my lord. By this order, they were illegally regularized, my lord. Their entry illegal, regulation illegal, my lord. Now, my lord, now I'll just straight away come to the latest latest recruitment rule, my lord, 2008 of Supervision Kanungo.
Where is it?
It starts from page 66, my lord.
66. Recruitment rule of 2008.
8, my lord. My lord, 8 and 69, my lord, educational qualification for SK is now by this recruitment rule 2008 has been made as a degree, my lord.
Earlier it was matriculate.
Yes, my lord. Page 69, my lord, will see the educational qualification for direct recruit. It has been made as degree, my lord, from recognized university.
They entered before this recruitment rules.
My lord, that is why, my lord, they were not. Now, this is now I've been, my lord, appointed under this 2008 recruitment through regular process, through selection process. There was a written examination followed by Viva Voice. And I've been appointed, my lord, by order dated 24 August 2009, my lord, at page 80, my lord, 81, my lord, this is the type copy.
Okay, as per the in 2008 rules, any changes apart from the educational qualification? The rest is same, isn't it?
My lord.
The rest are same?
Rest are, my lord.
Promotion from Mandal, 8 years required. Then direct 50% direct, 50% by promotion.
Yeah.
These are same?
My lord, only in
Only
this case,
matriculation.
promotion, my lord, in the column 12, my lord, page 69. The promotion for the post of SK from Mandal, it has been made 8 years, my lord. Earlier it was 3 years, my lord, in 2086, my lord.
8 years.
Yes, my lord. by this new act, it has been 8 years, my lord.
When is sir? You have to change the clock, the battery, I think. It's only 8:20.
Yeah, sure.
It's so early. Yes.
Now, by this 2008, my lord,
Hmm.
qualification degree, and for promotion, my lord, 8 years from Mandal, my lord.
8 years. Earlier it was how many years?
3 years, my lord.
3 years.
My lord.
3 years become 8 years.
Yes, my lord.
The metric has become graduation. It's become more difficult now.
Yes, my lord.
So you have promoted.
My lord, I'm not, now
you were appointed
I'm in, my lord, I've been appointed on.
from page 81.
Yes. My lord, at page 81, my lord.
Serial number.
Page 81, my lord, will see serial number.
What is your name?
Nakab, my lord.
Nakapina.
4, my lord. Serial
Serial
number
number
4.
4. Petitioner.
Yes, my lord. Serial number 4.
Recommendation of 23rd.
Yes, my lord.
Recommendation.
24 August 2000. On recommendation of so and so third. And for this, my lord, written examination was there.
Okay,
followed
there's
by-
no dispute, isn't it?
Yes, yes,
Nobody
there's no
has
dispute.
disputed.
Now, my lord, thereafter, my lord, at page 83, my lord.
Just a minute. Huh?
Assistant government officer. कुछ promotion का इसको तो टेलर से लेकिन promotion
83.
Yes, page 83. Madam, after this, madam, I've been sent for training by the department. At page 83, my lord, for handling latest equipment of survey equipment, my lord. This training is required, my lord. Now I have passed the exam, my lord. At page,
Where is your name, first of all?
at page 84, my lord, see serial number 9.
Page 1 of 11.
Page 84, serial number 9.
There is no.
Page 84, my lord. 20th, 29. It should be
That's your roll number. Roll number is 9. Serial number is 29.
Yes, the 59. Yes, the 29, my lord. Serial number 9.
Hmm.
Rule number 9. Nakab Hina Nabo, my lord.
Even for training.
Yes, this is on completion of the training, my lord.
How long is the training?
My lord, it's a, I believe it's a 6 month, my lord.
6 months. You joined in 2009.
Yes, my lord.
2011, there was a training. You were sent for training.
Yes, I successfully completed, my lord.
Then,
My lord, my lord, the post of assistant survey and settlement, my lord, this was earlier known as plain tabular, my lord. Plain tabular, my lord. Plain tabular, my lord.
plan
Yes.
tabular.
Yes, my lord.
Where do we get that?
Plain tabular, my lord. First, I'll come to the rule also, and this 104, my lord. By this order, my lord, the plan tabular was redesignated, my lord. Where 105, my lord. Type copy 105, my lord. The SK is in the category of group C, my lord. Now this plan tabular or other word assistant surveillance group B, non-get. This is redesignation of that plan tabular to the as the assistant survey and settlement officer. It has been read.
So your promotional post is either plan tabular or assistant survey and settlement officer.
Now, accordingly, my lord.
When you joined your service in the year 2009, there was a post of plain tabular.
Yes, ma'am.
That assistant surveyor settlement officer was not there. Only that plant tabular was there.
Yes, yes, ma'am.
So are you eligible to be promoted to that post?
My lord, that
If so, under what provision?
my lord, as per plain tabular recruitment rule 1986, my lord, page 111. That's the recruitment rule of 1986, ma'am.
Now, this plain traveler has been redesignated as assistant survey and settlement. Now, as per this,
What is the classification of post of SK?
task man. The classification man is a group C post man.
Group C post.
Yes.
Plant tabler also is a group C
No,
post.
it's now after by this redesignation manner, it has been categorized as a group B man.
By 1912, 2014 order.
That page 105 man is redesignated as
Correct.
10.
Prior to redesignation, it was group C post only.
Group C. Yes, ma'am.
Your SK post also group C.
Madam.
So there can be promotion between the group C to group C.
Later, madam, this has been categorized, madam.
Had it not been categorized, then what would be a promotion post? Plain tabler will be a group C post.
The general promotion would be surveyor.
Surveyor?
Yes.
From
I'll come to that point, madam, also. Surveyor.
From SK?
Yes, from SK to surveyor.
I see.
Now, under this plain traveler, madam, this is a plain traveler is a 100% promotion, madam. From surveyor, madam. 114, madam.
So as SK, you are eligible for to be promotion to surveyor.
Madam.
Now, you say that plant tabler is a post.
Plant traveler, madam, that's since, madam, at that point of now I've been, madam, after this, madam, there was a plant traveler vacant post. And the government, they have given me officiating promotion to the post of assistant survey and settlement officer. As well, it was known as plant traveler, madam. Not surveyor, madam. Madam, first my official.
Which is higher than surveyor.
Yes, higher than surveyor.
You got double promotion.
Madam.
Huh?
Yes, ma'am.
You got double promotion.
Yes, ma'am. Because on
from SK you have to go to surveyor.
Yes.
Then plant tabler.
Yes, but on administrative exigency, madam, I've been given officiating promotion to the post of assistant survey and settlement officer. Madam, and that has been regularized, madam. Madam will see the file noting how I've been given appointment to the post of survey and settlement officer.
Where is the file noting?
120, man, page 120. Type copy, man.
How did you get this file noting?
Madam, I have RTI, madam.
RTI.
Yes.
Which part? Page 120?
120, madam.
Yes, what do you want to show me?
Representation from so Sri Nakab Hina Nabam UP has submitted representation for promotion to post of assistant survey and settlement officer so may be seen. It may be informed that present incumbent to the post of ASO Sri Gopal Gamdak is retiring from the government service on on superannuation. Thereby, post of ASSO will stand vacant after retirement of present incumbent on 1st March 2016, which is required to be filled up immediately for planning in the district. Insofar, RR of post is concerned, of post of PT, that plant of now ASSO, is 100% promotional from surveyor of the department, RR so. However, it may be informed that PT post has been redesignated as ASO to assist the DLRSO in day-to-day field and office work, which require a person capable of dealing with the field as well as on office work in tandem with the DLRSO. In this connection, it may be also be informed that maximum educational qualification among serving surveyor is class 10 pass only. Therefore, if it is fit case, it is a fit case for one-time relaxation of RR to observe as a capable official from among senior SK The seniority of SK is placed on so. Sri HN Nabam, SK has been appointed a post of SK by order number so. He has undergone special training, special survey training at so Guwahati, which is capable of handling station, GIS, GPS, auto mapping, etc. as claimed in the representation. Therefore, file is put up for personal decision and further order. Authority is requested to consider his case as requested by the official at so vacant as vacant when. Sri Gamdak, Assistant Survey and Settlement Officer, is retiring on so. There's no eligible candidate in the surveyor post to be promoted to ASO. We require one surveyor supervisor Kanungo having expert in total station GPS mapping. Sri Nakap Nabam Hina Nakap Hina Nabam supervisor is expert in total station and GPS mapping. Therefore, Sri Nakap Hina Nakap Nabam SK may be appointed as Assistant Survey and Settlement Officer in the pay scale of so on non-gazetted official on officiating basis. Put up so. Now next page, my lord, one. As desired by Secretary LM at so file resubmitted for officiating promotion of Sri Nakap Hina Nabam, Supervisor Kanungo, to the post of Assistant Survey and Settlement Officer, non-gazetted Group B, against Gape Gamdak, Survey and Settlement Officer, who are retiring on so. Official promotion approved. However, DPC held at our list for regularization. So accordingly, my lord, at page 123, my lord, officiating promotion, page type copy of 124, I was promoted to the post of ASO, Assistant Survey and Settlement, on officiating basis on 2nd February 2016. 124.
123. Yes.
Then DPC.
And then, my lord, DPC, my lord, will thereafter. This is my lord, after this. Page 130, my lord. DPC was conducted, my lord.
The senior is there. 125 is senior.
One thing, my lord, that's before that, my lord, 125, my lord, page 125, my lord. After I was given officiating promotion to the post of ASO, man, 125, man. Final seniority.
ASSO.
Yes, man. Final seniority list of survey staff of land management was published, man. In that, the seniority list, my lord, as the survey staff, man, the supervisor in Kanungo, my name was not there. Because I was already given promotion to the post of ASO. It's not there in seniority list. My name is not there.
The seniority list is for supervisor.
Yes, yes, ma'am.
You were never a supervisor.
Since I was given promotion to the post of ASO, and this my name is not there in the seniority list of the supervisor in Kanungo. And thereafter, madam, while serving as a Assistant Survey and Settlement Officer, madam, the government, they have constituted DPC, madam. DPC, madam, you see a type copy at page 131, 131. Okay. 131. Minute of DPC proceeding dated 29 December 2016. Departmental Promotion Committee, DPC, constituted white order number so dated 28 December 2016, comprising of the following officers assembled in the office of so Secretary so for promotion of Sri Nakap Hina Nabam. He is official, who is officiating to the post of Assistant Survey and Settlement Officer. following so and so. Now from 2nd February 2016, the secretary was the chairperson of the DPC, director, and undersecretary. The department had placed all the relevant documents pertaining to the post ASO plan matter. Matter this not matter. All relevant document has been placed. Now, the department had placed all relevant documents pertaining to the post of ASO plan tribunal. As per material produced by the department, the lone post of ASO is lying vacant following retirement of Sri Gopal Gamda, who retired on attainment of superannuation from ASO on 29 February 2016. And Sri Nakab Hina Nabam is appointed on officiating basis in the post of resultant vacancy. DP is to examine the service record, SCR, and other relevant records of Nakab Hina Nabam with the proposal to promote him to the post of ASO and also to regularize his officiating service in the pay band of so-and-so. The DPC had examined all required particulars of the incumbent relating to ASO, DOSER, NOC, vigilance clearance, and are found to be in order, except, madam, this typographical mistake, madam, it's except, madam, except seniority list. Sri Nakab Hina Nab was already officiating in the post of ASO. His name has been taken out, omitted from the seniority list of supervising Kanongo by the department. That the department have taken out. It is in the notice of the DPC committee. The DPC found Sri Nakab Hina Nabam to be fit for promotion and regularization from the date of officiating promotion in view of the doctrine of continuous officiating under Article so and so. Now, accordingly, on the basis of this recommendation, DPC recommendation dated 29 December 2016, I was given regular promotion to the post of ASO, page 132 on 29 December 2016. On recommendation of on recommendation of departmental committee which set on so and so, the Nakab Hina is the promoted post of so and so with effect from 02/02/2016. Other term and conditions. But he was given regular promotion for DPC. Now,
What is this 2/2/16? This is the date of your officiating appointment.
yes.
Okay.
Now, this regular promotion order, that was also duly published in the State Gazette, page 133, third paragraph, 29 December 2016, on recommendation of so and so, it was published in the State Gazette, so and so, he ever promoted the post of assistant survey and settlement officer. This my recommendation and appointment was published in the Office Gazette, State Gazette. On 15 2017.
Page 133.
Yes, madam.
Where's your name?
My lord, see third paragraph, order 29 December 2007, madam. Third. Number LR 73/86, my lord. See. On recommendation of Departmental Promotion Committee set on 29 December 2003, Nakab Hina Nabam SK Land Management Department Sierra promoted the post of so and so, my lord. This was duly published in State Gazette.
Right, I know. We'll come back. We'll come back.
We'll come back to.
Lordship, I'm mentioning item number 8, Lordship. Can this matter be taken up next Monday, Lordship?
Mr. Meet. Mr. Tara is there.
I am for.
Any objection?
He is for the petitioner.
Any objection?
No objection on Monday, Lordship, next Monday, Lordship.
Let's wait for by Ms. G.A.T. Additional senior government advocate. Not objected to by the other side. This matter again on Monday. Please give the date, huh?
Highly obliged, Lordship.
16th, huh?
6.
Yes.
May I, my lordship, I beg to mention item number 15, my lordship.
Hmm.
This matter may be taken up on 17th. I have taken consent from the petitioner, my lordship.
Okay, let's wait for learned by Miss
K. Wangmo.
K. Wangmo, learned GA.
Yes,
Your
ma'am.
GA, government advocate, and not objected by the other side. List the matter on 17th of March 2026. Interim order passed earlier shall continue till the next date of listing.
I would like to mention item number 14.
14.
Yes, ma'am.
Yes.
I will choose time to file my affidavit.
Okay. You are okay now, Mr. Picha?
Yes.
Okay. You are for respondent number 3.
2 and 3.
Okay, Mr. B. Picha, learned counsel appearing for respondent numbers 2 and 3 submits that he may be given further 3 weeks time to file counter affidavit
May I, Lordship?
since he has not yet received instructions. Yes.
Lordship, I'm for the petitioner in this item number 14. Last chance may be given to the respondent to file their affidavit.
Last chance, why?
But they have taken 2 chances has already been given, Lordship.
Counsel for the petitioner submits that since enough time has been granted to the respondents, if time is granted, the same may be as a last chance. Start considering the fact that the matter is of the year 2025. Further 3 weeks time is granted to the respondents to file their counter affidavit. Petitioner may renew their prayer. Counsel for the petitioner may renew the prayer in case, in the event the same is required by the next date. This time I'll not make any observation. Next time we'll see. Okay. All right. Tagum,
Yes, ma'am. Now,
we are at which item was that?
at number 6, ma'am.
6. Okay.
Madam,
Hmm.
now, madam, I was given officiating, my officiating promotion to the post of Assistant Survey and Settlement Officer was regulated by DPC on 29 December 2016. Page 132, I have already mentioned.
132.
Yes, 132.
Yes.
Thereafter, my lord, at the page 34, my lord, page 34, the seniority list of ASO was published on 25 August 2021. Page 35, madam, 135. I'm the only loan survey and settlement officer in the department at that point of time.
135.
Yes. Ma'am. I'm the loan having after having gone through this training and all. Now,
Earlier, this post was under the name of
plan development.
Plan
Development.
Tabler.
Yeah, this has been redesignated
Hmm.
and known as Assistant Survey and Settlement.
Hmm. So there's no other plan tabular also.
Yes, madam. There's no other.
You're the only one.
Yes, madam.
Hmm.
And they are in the previous.
This is provisional.
Yes, provisional, madam. This is the only madam that has become final, madam.
Where's the final?
Only object, 1 page 34, If there's no objection, my lord, this will be treated as, my lord.
It's okay, but where is the final one prepared?
My lord, this is the only, my lord.
This is provisional.
Provisional. My lord, here it says that if there's no representation objection on this regard, my lord, it will be accepted as final, my lord. Correct position. At page 134, my lord, in their providing letter. If no second para, my lord, third para, if no representation received, it will be presumed that incumbent concerned have no objection to their respective position as shown in the provision seniority list and have accepted the respective position as correct. Representation received after expiry of so source, they will not be entertained. Now, thereafter, my lord, now my position to the post of ASO, my lord, it is confirmed by the DPC, my lord. Now, next promotional post is, my lord, DLASO, District Land Revenue Settlement Officer. And the earlier, my lord, District Land Revenue Settlement Officer, it was known as Land Revenue Settlement Officer Group B Gazetted, by Recruitment Rule 2006. Later on,
known as what?
My lord will see page 136.
LRNSO.
Yes, ma'am.
This was redesignated again.
Later on, by amendment taken place, this amendment was done, and that has been again redesignated as a District Land Revenue Settlement Officer.
District. So district was added, that's all.
Yes, ma'am. Only one point, Mala. As per earlier that rule, Mala, the promotion to the post of Land Revenue Settlement Officer, Mala, that were serving 8 years in the grade of tabular, Mala, plan tabular, that will be considered. That was there. Now, now come to the amended part, Mala. Now, 148. 140, 140. By this, the earlier Land Revenue Settlement Officer that has been redesignated as a District Land Revenue Settlement Recruitment Rule 2015 at page 140. Now, my lord will see the 140 Roman 6. Roman 6. Column 12 for existing entries. The following shall be substituted by the promotion from amongst one assistant survey and settlement officer, now redesignated from plant governor by government order number so and so, who have rendered 5 years of regular service in the grade. Now, for promotion to the post of DLRSO, requisite qualification and length of service for the ASO is 5 years.
Earlier?
Earlier it was 8 years.
Okay.
And for surveyor 11 years, that's this thing there. Malod. Then, Malod, in the year 2022, at 2022, DPC was conducted for promotion to the post of DLRSO. 143 page, the DPC minded is as 143. DPC meeting held on 18/10/2022, 18 October 2023, page 143 to 143. The type copy manner will see the page 45 onward, 145. 141 and 146, para 10. After detailed deliberation, para 10.
Para 10.
Yes, at 146 of this minute manner. Type copy, that the minute of DPC dated 18/10/2022, my type copy, it start from 145.
No, para 10 does not start like that. You said para after detailed discussion.
No,
Where
no,
is that?
my lord, this after, I'm going to only operating portion only. The detail, my lord, 145, it start.
Then why do you say para 10? You read para 10 if you say para 10.
My lord.
From where you want to read?
My lord. Para 10, my lord.
Serial 10, my lord. Page 146.
146, my lord. I was recommended my serial number 1, first one.
No, para 10. Para 10, serial number 10 says DPC has perused all relevant documents.
Yes, my lord.
So
This is the one.
then you have started saying after.
My lord, I'll just the 145 for the time being, my lord. See, I'll just.
You're trying to simplify things, but
Yes,
it's not simplifying.
my lord, that is why, my lord.
You are confusing me instead.
My lord, 145
Hmm.
for convenient, my lord. My lord, the DPC, Department Promotion Committee. The Department Promotion Committee meeting was held, my lord, this is typographical, it was held on 18/10/2022.
No, you don't have to read the entire thing. You just show me the relevant portion. That's all.
No.
Where are you? Serial number 1.
My lord,
You're at serial number 1.
yes, my lord. Serial
DPC,
number 1.
department has placed the names of the following candidates, so and so. Number
Yes,
1 is the
serial
petitioner.
number 1.
Then where's the recommendation?
Serial number, now. Recommendation is 11, my lord.
Private respondents are there.
My lord, private respondent number 4 is there.
Where is he? What's his name? Serial number?
Serial number 2, my lord.
Serial number 2. Jangro.
My lord, he's in 4, my lord, in the first, my lord, he's in 4. That is John of Consider, whosoever in John of Consider has been listed all together, my lord, 8, my lord. The first page, 145, my lord.
Simple question. Is the private respondent name available here?
My lord, in John of Consideration.
Where is he?
Serial number 4, my lord.
What is his name? Tama.
Tama Dakwe.
This is respondent number 4.
4. And 4. No, the 4.
4.
And respondent number 5 is serial number 5, my lord.
Mipang is R5. Okay.
Yes. They're in zone of consideration.
Zone of consideration. Then next page.
And then next page, my lord, para 10, 146, my lord.
How does your para 10 starts?
DPC has perused all relevant documents of the records placed before it and found the following officer fit for promotion in order of merit. Number 1,
Petitioner.
ASO.
Petitioner.
Yes, ma'am. Petitioner.
Number 2.
And 2 is Tama Dakpe SK.
Who is he?
This is the respondent number, private respondent number 4.
Okay, R4.
Now 11, my lord.
Hmm.
11, DPC recommend Sri Nakab Hina, ASO, Nabam Hina, and Tama Dakpe, who have requisite service and other qualification as per recruitment rule and found fit for promotion to the post of dealer. So from the DPC's recommendation, this is a DPC recommendation dated 18/10/2022.
There were 2 posts. Two vacancy.
My lord.
There are 2 vacancy or what?
My lord.
DPC has recommended 2 names. Your name as well as the respondent number 4.
Yes, my lord, 2 posts. My lord, the 1 page 145, para 3, it's clarified. It's clear. Department has briefed the committee that 2 posts of dealer so group B.
Okay. So thereafter,
against these 2 posts, my lord, I was recommended as a serial number 1, as the first serial number and second respond number 4. Then, my lord, despite the recommendation, my lord, matter was kept for 8 months without any statement. My lord, suddenly, on 22 June 2023, DPC was held on 18/10/2022. Then, after 8 months, on 22 June 2023, at page 150, my lord, see, the file was put up.
.47, why this read?
My lord, against this, since recommendation was made way back in 2010, my lord, 2022,
What-
since it was kept pending for 8 months, then I also approached this honorable court by filing at page 147, seeking direction to dispose of that recommendation, my lord. And later on instruction, it was informed that that has been reviewed and cancelled, my lord. Accordingly, the writ petition was withdrawn. Page 147, my lord, earlier. Then after filing, my lord, the petitioner come to know that this all development.
So you have to withdraw it.
Yes, and to challenge this subsequent development. Now, 150, my lord, it's original file noting. It's a start from file put up.
Does it have a date?
At my lord, page
149 has a date and a month. What is it?
my lord, this type copy is at 150. my lord.
149. Type copy doesn't have any date. That's why I'm asking you to see 149.
Yes, ma'am. That doesn't have. Only down below my signature SK.
There is a date we cannot.
There's a
That is
date
not legible.
and month.
Yes, not legible. I could not ascertain it. Now,
Is it
Type-
26? 20? No, it can't be 6. 6. 6, of course. You said 8 months. DPC was 18/10/22.
8 months.
So if you add 8 months, it becomes June of next year. Probably this is 20 of June 2023.
Next page 150, my lord, will see that this is just to show that how the file was put up after 8 months.
I understand, but I was asking you about the date. That's why.
That matter is not.
Your type copy doesn't have any date. The original copy has a date which is not legible. Perhaps, but it is 26. Anyway,
Yes, ma'am.
then
Page 151. On 23, my lord.
that's what this is 23/6.
Yes, 23/6.
So note was prepared on 26. This is 23/6, 3 days after. It explained that. Then
Another, on 23/6/2023, my lord.
what is the outcome?
Department promotion comprising of following will sit on so and so in the office of Secretary to review the promotion of Sri Nakab Hina Nabam from SK to post of ASO. And
No, you come to page 2053 straight away. You no need to read the notice and all that. Come to page 33, page 153. Type copy. I hope you have typed it right. Annexure 33. Show me the relevant portion.
Annexure na. Basta no comment.
154.
हम लोग का reply man.
154. The revision is, my lord. 154 under para 8, my lord.
Okay, read paragraph 8.
Records provided by the department shows that all the candidates except in para 8, A, B, C, and D mentioned below have requisite service qualifications prescribed under recruitment rule. However, following observation were made by the committee. This review committee, man. The promotion in respect to Nabam Nakab Hina from SK was consulted with AR department, and accordingly AR department has advised the department, which is highlighted below. Department has stated that RR of ASO was upgraded from planned tribunal were not framed. The qualifying service for promotion would in such case be as per norms. If there's an error apparent on the face of it with respect to DPC, recommendation for regular promotion at page 11 so the remedy is to place the matter before the review DPC to take a view. The department has stated that Honorable High Court had directed to reconsider the entire matter with respect to the case filed by one Sri Rana Ngodang, afresh in terms of earlier order number so. WPC 162 of 2015.
This is not your case?
This is not my case.
Okay.
I'm sure that even in the what this order as I have annexed it also to dispose of the representation and to consider his case for promotion to DLRSO. Department may examine the principle enunciated in this this judgment at its level. Law Department in its advice has not pointed out any legal principle regarding belated review DPC. Department may accordingly place the matter before the competent authority for appropriate action as per a guideline pertaining to review DPC. In view of above, DPC has not considered the case of Sri Nakab Hinanabam. Further, it has been apprised that Rana Ngudang petitioner in the above writ petition has already expired. Now, this is the review, my lord. Now, thereafter, after reviewing, my lord, at page 155.
What is the sum and substance of these minutes?
My lord, there, 155, my lord, my name has not been considered, has been turned down, and in my place, 2 private respondents whose illegal appointment has been recommended.
Okay, what is the reason behind that? Is it shown in the minutes?
But it is not proper.
Page
Hmm?
154, serial number 8.
This is the only one. 150. This is not
No, you just read just now.
just now. Yes, only referring one WPC 162 of 2025 filed by one Sri Rana Ngudang. But whether it is relevant or not, I have enclosed the order also. This Rana Ngudang, who already expired.
Order was framed for the ASO and
What is the reasoning? There is no reasoning.
No reasoning, my lord. No reasoning.
It talks about one Rana Nadang's case.
Yes,
Rana Nadang is no more.
no more. Now these
Where is Rana Nadang's case? Just show me the order.
my lord, we'll see at page 156.
Let's see that first. He was also a contender with the
No,
post.
he was not contender at all in the DPC, my lord. He was already expired. As in the DPC itself.
No. During his lifetime,
Yes.
he was aspiring to be a promoter to the post of
DLRSO, my lord.
DLRSO.
My lord. My lord said.
But you said that in the seniority list of a assistant, what is
Survey
that?
and settlement officer.
You are the only person.
I'm the only person. And
So from where does he come then?
now he is SK, my lord. There's a two-way of promotion, my lord. For ASO, 5 years.
No, from SK you have to become a surveyor first.
My lord, but by virtue of the amendment 2000, latest amendment of DLRSO 2015, my lord, there's either SK can also be promoted to the post, but their length of service is different, 15 years. And for ASO, for 5 years, my lord. This is there, my lord.
ASO 5 years, and if you are
SK
is 15 years.
Yes.
Okay.
Now, this operating portion, 161 of his representation has been directed to dispose of within 60 days.
What was he? He was an SK.
He was SK. Now, in compliance with this order, my lord, one direction of this order passed in WPC 162 of 2015. Directed there 161, my lord. This order was already complied with by the Commission on Land Management at page, my lord, it starts from 160, type copy 163, my lord.
What is there to comply? To consider and dispose of the representation? That's all.
Yes, that is only. And accordingly, Commission have disposed of.
In what manner?
Saying that the claim of the petitioner is not just the word. There's no merit in the claim of the petitioner.
Only prescribed for minimum.
This, what is the name?
Rana Ngudang.
Rana Nadang.
Yes.
Nadong.
Ngudang. Madam C1, type copy 163.
No, you see at page 154, it says Rana Nadang.
Yes.
Nadong.
Ranang. This is the same.
So what is your case?
Now his representation as director 162 of the 2015 WPC manner, his grievances has been disposed of, considered by authority, saying that his claim for promotion matter has no any substance.
And what is the reason given?
Man will see at page 163. 163. The speaking order passed by the Commissioner of Land Management.
Yes, which part of the order is the speaking one? Show me.
My lord, the para 6, my lord, he was not para 6, my lord, will see 163. It is the fact that the government office memorandum so and so has fixed the minimum educational qualification of graduation, bachelor degree in the discipline for the discipline from recognized university for considering appointment group B, group A service by the direct recruitment or promotion. It is also a fact that the gradation of OM has been kept in abeyance for the period of 4 years, so and so, by so and so.
Okay. Okay. Is it like this that he was not a graduate?
My lord.
He was not a graduate, that's why.
And that's why.
He does not have any.
Yes, his grievances have been turned down by the commissioner.
Then?
Now, thereafter, my lord, this is, my lord, how my DPC in respect of Dilarso recommendation earlier has been turned down, citing the order passed in WPC 160 of 2015, filed by one Rana Ngudang, who has already expired. Now, there's no reasoning at all for turning down. Now, thereafter, my lord, my DPC in respect of Dilarso that has been turned down. Then thereafter, on the same day, another DPC was against conducted simultaneously.
After review?
Yes, after review of my DPC in respect of Dilarso, Disciplinary Revenue Settlement Officer, on the same day, simultaneously, at page 166, my lord, that is for review of my promotion to the post of ASO, which was regularized and promoted in the way back in the year 2016. After 7 years, again they started, my lord, the review DPC started at page 166, my lord.
So what happened after that? DPC?
After that, my lord, at page 167, my lord.
Yes, after 167, what happened?
One view of my recommendation to the my appointment to the post of promotion to the post of ASO has been recommended to be withdrawn.
No, that I've seen. So what has happened thereafter? Has it been withdrawn?
That has not been, because there's an interim order, man. In this,
then no. After this, you came to the court.
Yes, immediately, and there's direction not to give effect to this.
Immediately after the DPC of 23/6/23, you came to the court.
Yes, yes, ma'am.
Okay.
Now, this is the whole sum of the case, the fact in sum and substance. Arbitrarily, without any proper reason, my regular promotion to the post of ASO, as well as recommendation to the next higher post, that has been turned down.
And in the to my writ petition, madam, to the contention made in writ petition, madam, the government, the respondents, they have filed the affidavit. They have not justified as to how illegal appointment has been overlooked, and those who are regularly meritorious candidates have been found, they have not justified on their affidavit. Only their ground, the mention in the affidavit is that there's a guideline of the government of India for conducting DPC, and there's a provision under a particular clause, madam, that 18 point all the contention that I've raised regarding illegal appointment, although this has not been justified, that has not been answered by the state. Only the ground they have cited is one guideline of the government of India, particularly para 18.1, saying that there's a provision for review of DPC, and accordingly, as per this provision, we have reviewed it. And your earlier promotion, it has been turned down, recommended, my lord. My lord,
yes.
my lord, what this is, their guidelines, and the affidavit in opposition filed by respondent number 3, they have annexed. Page.
No, before that, let us just go back to that DPC. Where's that? Review DPC.
Review DPC, my lord.
Page 154. Starts from 153, but the main thing is 154.
Yes.
So paragraph 8A is the main reason.
Yes, only 8.
That is the only reason.
Yes, ma'am. Now, in the affidavit, madam, they have come up with one guideline saying that one
whose affidavit?
Affidavit filed by respondent number 3.
Page number. Page number.
Page number. My lord, page number 188.
188, yes.
Sorry, my lord, 183. Yes, 183.
These are statements.
Yes, only statement, para 7. My lord, this they have cited that based on.
There is no para 7.
27, my
No.
lord.
7 and 27 are not same.
That's only, and now they have supported, they have, in support of their statement, they have annexed the guideline. Relevant.
In support of what?
Saying that this, they have a power to review that has been reviewed as per the guideline, man.
No, in support of what?
In support of this.
In support of them having conducted review DPC.
Yes.
Okay.
Only since there's a provision for review, that's why they have.
What is that provision?
Provision is at page.
It's a office memorandum.
Yes, ma'am.
Of 1989. Is it annexed?
Yes, ma'am.
Where is it? Where is it next? Section 9.
It starts from 202. 10th April 1989.
202.
Now, relevant provision is at page 229. Review DPC.
It's a big office memorandum.
Yes, ma'am.
Page number 229. 229.
Part 6. Review DPC.
These are all one document.
Yes, ma'am.
Starting from page 202,
202, and operating.
guidelines on DPC.
Yes,
Operative?
229, my lord, 18.1, which they rely.
Yes, please read.
The proceeding of any DPC may be reviewed only if the DPC has not taken all material facts into consideration, or if the material facts have not been brought to the notice of the DPC, or if there have been grave error in the proceeding followed by the DPC. Thus, it may be necessary to convene review DPC to rectify the certain unintentional mistake.
Yes, ABC, read that.
ABC A, where eligible person were entitled to be considered.
Omitted.
Yes, where your
Omitted.
where eligible person were omitted to be considered, or where ineligible person were considered by mistake, or where the seniority of the person is revised with the retrospective effect resulting in the variance of the seniority in the list placed before the DPC, or where some procedural lapses, procedural irregularity has been committed by the DPC, where adverse remark in SEER were toned down or found after the DPC had considered the case of the petitioner. These instances are not exhaustive but only illustrative.
Okay, have you gone through the entire OM regarding the review?
My lord.
Does it provide a timeline?
No, man. There's no timeline.
There's no timeline. So the review can be done anytime.
My lord, as per their version.
After 5 years, 10 years also.
Yes, man. That is why that is the challenge, subject matter of challenge, my lord. Now, in this regard, my lord, in response to their
So what according to them was wrong in your case?
in my case, my lord, already, my lord, I have in the file noting manner in which my case for promotion to the ASO was considered and taken. This has been brought on record that DPC have considered all aspects. Nothing has been.
That is your explanation and in your submission. I'm asking you,
The government.
as per the government, why did they have to call for that review? Because a DPC had also said to consider your case.
Yes, my lord.
Retrospective, and initially it was officiating appointment, correct?
Yes, my lord.
That was regularized by way of the DPC.
Yes.
And there's an office note or the file notings which says that since there's nobody, you should be given the chance to be promoted to that post. And accordingly, they had acted upon that.
Yes.
So decision was taken.
Just assisting us.
Hmm.
Page 166 and 167, my lord will find the review.
On the counter affidavit.
No, in the main petition. 167 is. Because he also did not qualify, no RR was framed for the ASO.
My lord.
No, before this 166 and 167, there was 153 and 154 also.
Length of services.
Exactly, my lord.
Consequences.
Which says that review has to be conducted again. So hence 166, 167 took place. But what was the reason given in 153 and 54 is not clear. Mr. Tagum,
Yes, ma'am.
show me that document where you say that some office noting was there and person there too, what was done to you? You had submitted some application for promotion to ASO.
My lord will see at the my lord
extract of file noting next, my lord, page 120.
120.
My representation is 1152.
Hmm. That time, what were you?
My lord, I was SK.
You were SK.
Yes, madam. And the file noting, since there was ASO post Poland vacant because of superannuation, nobody was there to man the post, madam. And on administrative exigency, they have given me officiating promotion. And it is transferred from the file noting, madam, at page 120.
And this officiating promotion was then considered by the DPC.
Yes, madam.
Where was that?
DPC, madam, at page 133, madam, 131.
131.
DPC held on 29 December 2016, wherein detailed discussion was made, including there's no other eligible 131.
One 132 is the order.
131 DPC, madam, how they have considered.
So this was reviewed.
This was reviewed, madam.
Reviewed by which order?
Reviewed by
which DPC?
reviewed by my lord. Reviewed by my lord
153.
DPC that 23/6/2023.
Where's the mention about this DPC of 29 December 16?
My lord will see page 1.
Yeah, this was
66.
99.
166.
Yes, madam.
No, that
Copy, madam, 168, madam.
166 came later on. Huh? Before that, 153 was there.
Same date.
DPC,
Same date, madam.
Same date.
same date means?
On the same day.
On same day.
Oh, okay, same date. All right. Same date, there were two DPCs, review
Yes.
DPCs.
Review DPC.
And
The one
composition,
earlier, my recommendation to the post of DLRSO that was turned down on same day. After having turned down again, the previous already promotion to the post of ASO was also reviewed, madam, on same day, which was done year 2016, madam. The type copy, madam, 168.
that was by two different minutes, isn't it?
Yes, madam.
It is not one,
Not one.
one consolidated minutes.
Yes.
It was.
Madam, one type copy of next 158.
168. The post of ASSO was created, redesignated newly, and no RR had been framed. Therefore, regular promotion could not be granted from SK to ASSO. It should have gone by the zone of consideration and the seniority, with both criteria being considered.
Everything to alert.
There was material defects and violation of guidelines of conduct of DPC. Hmm.
1989. Oh.
Madam, the file noting, it's speaks, madam, my promotion to the post of ASO, madam, it was on administrative exigency, since nobody was there, eligible person. to hold the post, madam. I was given, and I've been holding the said post on regular basis for the last 7 years. And after 7 years, all of a sudden, madam, the impugned DPC review that has been done, that's a double shot, madam. Promotional higher post that has been turned down, which is already recommended in year 2022, that has been turned down by 23 June 2023, and my promotion to the post of ASO, which was done year 2016, was also sought to be reviewed and recommended for reversion.
Okay.
In response to their affidavit, my lord, I have filed my rejoinder, saying that since their only contention is that so far private response, why there's a discrimination? The person who has entered to the service illegal backdoor, you have prioritized them, given preference over them, illegal appointment over the person who was meritorious candidate, madam. That part, they say that no, they have been regularized. Whether the authority has a power to regularize by way of DPC to the illegal appointees or not, madam. That also I raised, but it's not possible. It is not permissible under provision under traveling law, madam. I have contended their replied their affidavit of opposition, and with regard to the specific para that have relied page 1, clause 18.1, that which they have relied, madam. I have clarified my stand, madam. Whether it is tenable or not, madam, I have clarified my point, madam. 9.2 on board of my affidavit in reply. The clause page, madam, 309 of my affidavit in reply, madam. 309. Apart from other reply I made with other aspects, since they're harping on the point of 18.1, madam. That's skipping other part and striking on my reply to their contention, madam. 9.2, madam. 309. That is
Just a minute. 309 is not 9.2 in my copy. It's 9.4.
there's a 9.2, madam. There's very
9.2, how does it start?
that as per clause
18.1. Okay, this is 306 in my copy.
As per clause 18.1 of the office memorandum dated so the proceeding of DPC may be reviewed when recommendation of such DPC has not been culminated into formal order of promotion or appointment. Under clause 18.1 of the office memorandum dated so it is crystal clear that proceeding of DPC may be reviewed, but it does not mean that the respondent can demote the employee to the lower grade of post at any point of time, even after 7 years of regular service in the promotional post without issuing any notice or without affording opportunity of being heard to the employee. The proceeding of DPC may be reviewed so long as recommendation of DPC is not culminated into final order or promotion or appointment. However, once recommendation made by DPC is culminated into final order of the promotion or the appointment, it confers substantive legal right upon the employees, and such promotional order cannot be cancelled or reverted back
to the promotees to the lower grade post without issuing any notice and without affording opportunity of being heard and without following a mandate of constitutional provision as provided under Article 311, Clause 2.
So you're not denying the fact that it's possible. It can be done. Only thing that notice has
It has not been acted upon. But in my case, the DPC had duly considered and having seen all, and that recommendation has been acted upon and issued a final order. And I have been serving by the strength of that order. I've been serving as a ASO for last 7 years on a regular basis. And I'm eligible for the next promotional post as a dealer showman. Already eligible, man. Because from the post of ASO dealer show is 5 years, and I have already completed length of service for next promotion. Next month, 9.3 matter. That clause 18 point of the office memorandum that talks about the review of DPC, but it does not talk about the cancellation of the order promotion already given. This merely relying on thus merely relying upon the clause 18.1 of the office memorandum dated so. The respondent cannot take away the right of the petitioner, which has already acquired white order number so in 2016, 29/12/2016, pursuant to DPC held on so after lapses of more than 7 years, and that too without following the mandate of Article 311 of the Constitution and statutory provision of Rule 1(4) of the CCS Rule 1965. It is pertinent to mention that clause 18.1 of the office memorandum that is a mere guideline, administrative instruction, and as such, it has no any statutory force. Therefore, such guideline cannot be interpreted to negate or override the mandate of Article 311(2) of the Constitution of India and statutory provision 14 of the CCS Rule 1965. Thus, that being the position, the clause 18.1 of the office memorandum that cannot be interpreted or misused by the respondent authority to negate or override the aforesaid constitutional and statutory provision to demote the petitioner from the post of ASO to the post of SK after 7 years of regular promotion. It is now settled position of law that the guideline administrative instruction cannot override the statutory provision. Situated thus, respondent authority ought not to have demoted the petitioner from the post of ASO in flagrant violation of mandate of constitutional provision under so and so for Rule 14 of the CCS Rule 1965. In curve of review under clause 18.1 of the office memorandum dated shown, hence the impugned review DPC dated for demoting the petitioner from the ASO to SK, cancelling recommendation made in favor of the petitioner for promotion to the post of dealer show by the respondent authorities liable to be settled and so. And another point also I have marked, they're saying that they were appointed prior to my appointment, and there are 9.4 it is settled principle of law that illegal appointees cannot be allowed to march over the regular appointees in the matter of promotion or seniority, even if they were appointed prior to the appointment of regular appointment. Thus, the manner in which the regular appointees like the petitioner has been deprived of his promotion to the post of dealer show at the instance of illegal appointees like the private respondent, the only to accommodate them is a clear case of arbitrariness and discrimination against the petitioner. Hence, illegal and arbitrary action of the respondent is liable to be interfered with this honorable court and etc. Now, here, even in irregular appointment, they cannot be allowed to march over the regularly appointed. This is the case of illegal appointment, utter illegal. It's not a case of irregular appointment. There's a certain judgment where wherein it is held that if the appointment is irregular, not illegal appointment, then such irregular appointment, they can, in the seniority, in the promotion, they can put below the regular appointees, irrespective of whether they were appointed prior to that regular appointees or the other. That doesn't matter. But the thing that when matter is taken into consideration for promotion and seniority, the regular appointee has to be given priority, not the irregular appointment. But in the present case, it is a case of illegal appointment, utter violation of all provision.
You say it's illegal appointment because the rule provides that it should be by way of selection.
Yes, no selection process.
They were appointed on officiating basis.
Yeah.
And later on they were regularized.
My lord, that I'm challenging that regulation order.
To know whether that regulation, they can do or not, my lord. In that,
You were also given officiating appointment,
yes, my lord.
later on regularized by
Yes.
DPC,
Through selection process, my lord. My initial appointment is through selection, my lord.
was by selection.
A competitive exam, written exam conducted, and viva voice, and thereafter on merit, I can.
No, from that assistant post,
Assistant post, my lord. My lord, the assistant post, my lord, it is also settled, my lord, ASO post. If the initial entry of the petitioner and the person is legal, well, then the exception is there, my lord. Order that rule can be waived, it can be relaxed, my lord. That is settled, my lord. And to that effect, they have in their file noting, they have clearly categorically stated that that rule has been the relaxation provision has been invoked because petitioner is the only eligible and qualified candidate to handle the post of the ASO, my lord. That in their file noting that that is permissible under law, my lord. There's a series of judgment on this aspect also. But so far the private respondent is concerned, their illegality cannot, their illegal appointment cannot be cured by way of DPC. And mine is not the initial appointment. Appointing is a promotion. After having entered into service on legally, on valid, regular process. In that case, the condition service can be relaxed, not the recruitment rule. Since the post of ASO is 100% promotional, 100% promotional post. And there's nobody to handle the post, and the petitioner at the relevant point of time, petitioner was there. Only non-eligible.
Where is that order, 2260?
My lord, that promotion, my lord, promotion order 132, my lord. File noting, my lord.
No, before that, that was the regularization after that DPC said.
Okay, my lord.
Before that, there was another order.
123 officiating AS.
123.
Yes.
123. And before giving me officiating promotion, my lord, the file noting is there, justified by the department. Why my officiating promotion is required at the department? Because nobody was there to handle. Therefore, not administrative exigency.
No, that was what I was indicating.
My lord.
Not your initial appointment. I was talking about your officiating promotion,
Officiating promotion.
which was later on regularized.
Yes, madam. And
Otherwise, this officiating promotion has to be done by way of what?
But
DPC.
only, madam.
Sarviatun.
That DPC on administrative exigency, I was promoted to the post of ASO on officiating basis, and later on it's regularized. And manner in what ground on which I was given officiating promotion to the ASO, that their official file, it is the speaks of itself, man. That there was nobody, and even regarding the relaxation of rule has also been discussed, considered by the authority. In that circumstance, in the interest of public service, the one-time relaxation has to be granted according to that has been approved at page 122 or 120 of the file noting. The file noting speaks of
below this.
120 maladies. I'll again measure is.
Your file noting.
Yes.
Page 120.
Page 120 of writ petition. It may be mentioned that present incumbent to the post of ASO retiring on so thereby post ASO will stand vacant, and after retirement the present incumbent required to be filled up. For planning in the district. Insofar RR, the post is concerned, the post of Plan Tribunal Resort, now SSO is 100% promotional from surveyor of the department. RR place also. However, it may be mentioned that PT post has been redesignated as ASO to assist DLRO in day-to-day field work, field and office work, which requires the person capable of dealing with field as well as office in tandem with DLRO. In this connection, it may be also mentioned informed that maximum educational qualification among the serving surveyors is class 10 pass only. Therefore, it is a pit case for one-time relaxation of RR to absorb a capable officer from amongst the senior SK. The seniority of list of SK is placed on you. Don't have power. Second one. Sri HN Nabam, SK has been appointed to the post of SK, white order number, white so-and-so, dated. He has undergone special survey training at ASO, DC, which is, and he is capable of handling station, GIS, GPS, auto mapping as claimed in the representation. Therefore, file is put up for personal decision and for further order, please. Authority is requested to consider this case as requested by the official, as requested by the official responsible to beckon as when. The so-and-so survey settlement is retiring on so-and-so. There's no eligible candidate in the survey post to be promoted as ASO. We require the supervisor in Kanungo having expert in total station and GPS mapping. Sri Nakab Hina Nabam, supervisor is expert in total station and GPS mapping. Therefore, Sri Hina Nakab Nabam SK may be appointed as the assistant survey and settlement officer in the pay scale of so-and-so on officiating basis. Next one. As desired by the Secretary LM, so the file resubmitted for officiating promotion of SK of Sri so-and-so supervising control post of the SK survey and settlement officer against so-and-so and settlement officiating promotion approved. Our DPC held unless it should be DPC be held at unless possible for regular promotion. Accordingly, letter on regular promotion was done by conducting regular DPC. And DPC have the detail they have discussed. Minded of DPC at page 131. My lord. Their detailed reason they have some reflected in DPC. 313.
131.
131. Regular DPC held on 29 December 2016.
Ultimately, 166, 169, 167.
Yes.
Correct.
Yeah.
Then by way of interim order, this has not been given effect to.
Yeah.
No.
Yes.
Now, this is the case, my lord, regarding their contention, the document as well as private respondent. Their contention also that since they have been regularized by DPC, there's nothing illegality, and they can be considered, and even they can march over you. There's no issue. What their contention is. Now, in this regard, in my reply, I have categorically said that when their appointment's illegal, this cannot be cured by way of DPC matter. In these, on background of my submission matter, I've compiled the certain decision matter.
Give us also.
I have categorized my judgment in three parts. The first judgment on illegal appointment, which is against the private respondent 4 and 5, and thereafter again judgment on point of law that no reversion or cancellation be done without following the due process of law, and whether OM
can supersede or can override the statute. Now, first, Malad, first case, serial number 1, Maharani versus Malad. Page, compilation page 14, Malad. There are 35, 39, Malad, I guess. 14. Maharani.
Rani, na? Citation number?
Citation number 2004-7 SSC 112. And para 35. That is wholesome illegality cannot be cured by resorting to regulation or deficient. There are 35. No appointment therefore can be made in deviation of or departure from the procedure laid down in the said statutory rules. There are 39. Regularization, in our considered opinion, is not and cannot be a mode of recruitment by any state within the meaning of Article 12 of the Constitution or anybody or authority governed by the statutory act or rule frame thereunder. It is also well settled that the appointment made in violation of the mandatory provision of the statute, in particular, ignoring the educational qualification and other essential qualifications, would be wholly illegal, and such illegality cannot be cured by taking recourse to regularization. 40. It is equally settled that those who come by back door should go through that door. Para 43. This yet again, and so on quoted the earlier decision. The appointment itself is infraction of the rule. It is in violation of the provisions of illegality cannot be regularized. Rectification of regulation is possible, an act which it is within the domain and provision of the state, but there has been some non-compliance or procedure of manner, but which does not go to the root of the appointment. Regulation cannot be said to be a mode of the recruitment. To exceed such appointment would be to introduce a new head of the appointment in defiance of the rule, or it may have the effect of setting at naught the rule. 44. The decision of this court have received the approval of the 3-judge bench of this honorable court in so-and-so, wherein it was held that procedure for appointment as contained in the rule framed under 309 Constitution must be complied with. No regulation, next 45, no regulation is thus permissible in exercise of statutory power conferred under 162 of the Constitution if the appointment have been made in contravention of the rule. Yeah, sure. 45. Now, next matter is Nagendra Chandra versus State of Jharkhand. It's a 3-bench division Constitution bench. That is, if the appointment has been made without public advertisement and violation of the rule, it's an illegal matter. Page 23, it's a operating portion. Page 23, para 4. In Secretary of State of Karnataka, Umadevi, the Constitution bench of this court laid down that any appointment made in violation of recruitment rule with the violation of Article 14-16 of Constitution of India, rendering the same nullity. As such, even if the appointees has continued in service for a long period, it cannot be further allowed to continue in service. But if, however, it is found that appointment was not illegal but irregular, in that eventuality, he could be permitted to continue in service, and same could be regularized in case he had worked for 10 years or more on duly sanctioned post. The Umar Devi's matter, that is Umar Devi case, is in respect of irregular, not against illegal appointment. Now,
Right.
Para 5 as well, Malad. Thus, the question falls at 24. Thus, question falls for our consideration is as to whether the appointment of the appellant being infraction of the rule so and so of the Bihar Police Manual are regular or irregular. This detailed manner of discussion has been made. Now, ultimately, para 25 months. In National Fertilizer Limited versus so and so, this court was dealing with the case of recruitment under Rule 1.5 of the recruitment and the promotion rules, which required the direct recruitment by advertisement. The appointment were made without advertisement by the public sector undertaking, which is within the state, within the meaning of Article 12 of the Constitution. Those appointed filed a writ petition before the High Court for regulation of their service, which was allowed, and their service were regularized, challenging the said order. When the matter was brought to this court, the order of regulation was quashed on the ground that initial appointment were nullities in view of the fact that same were in the fraction of the rules and violated Article 14, section of the Constitution. Court observed. Next matter, the para 9, page 26. In view of the foregoing discussion, we have no option but to hold that if the appointment is made in fraction of the recruitment rule, same would be violative of Article 14 and 16 of the Constitution, and being illegal, being nullity, would be liable to be cancelled. In the present case, as the vacancy were not advertised in the newspaper, the appointment made were not only infraction of rules also, Bihar also, but also violative of Article 14 and 16 of Constitution, which rendered the appointment of the appellant as illegal, and as such, the competent authority was quite justified in terminating the service, and the High Court, by impugn order, quite justified in upholding the same. Now, again, in the subsequent judgment 2009 manner, in state of Upendra case, Upendra Singh, Upendra Narayan, Malad, here also Malad principle laid down. If the appointment, if it is not initial appointment has been made without any public advertisement through employment exchange, which is in violation of Section 4 of Employment Exchange Act 1959, such appointment is illegal and violative of doctrine of equality. Such illegal appointees cannot claim any relief even on the ground of humanitarian on being continued for long servicemen. The principle of equality, Article 14 of the being positive concept, the illegality cannot take benefit of the precedent of wrong order path. But this is some and such as summarized in detail manner, para 25, 27, 51, 52, 57, 59, 60, 55, 66, 67. Detailed discuss has been made with reference to Section 4 of Employment Exchange and other. Just in the index, I have not the
paragraph numbers.
Yes, paragraph number and gist of the.
Yes.
Page, it starts with page 27. And relevant paragraph, it starts from page 41. Para 25. The page 41, para 25.
Page 41.
Yes, madam. Of Upendra, madam. Page 41. Para 25. Para 25, page 41.
41 is your own pagination, isn't it?
Yes, on pagination. For convenience, madam. In compilation, madam.
But in the index, you have not given your pagination.
Madam, index I have given, madam, at madam, see, page 27 to 29, madam, this deals with the state of Bihar versus Upendra Narayan. Now, relevant paragraph, they are within bracket, madam, it's the relevant paragraph in which the page number is there, madam. Page 41 is deal with relevant paragraph. Para 25, madam. Para 25 is start from page 41.
It's okay, you don't have to read the entire thing.
This thing, madam, and
all right, you have given the gist anyway.
Yes,
This will suffice.
yes, madam. Now another, madam, at Mamta Mohanty case, madam, case number 4, my lord.
Initial appointment order bad in law.
Yes. Then all consequential order there will be none is in the eye of law and no adverse position can be claimed on leading post on a ground of long service. Saying that I've been holding for the last 10 years, I should be given, I should be protected. That claim is not available to those illegal appointees. And same as that of District Bar Association pre-judge bench, my lord. The state and its instrumentality cannot validate the illegal appointee in regularization. Para 26 and 30. Same as again 2025 live law, para 38 and 40. Held that if the appointment is illegal, it is none in the eye of law, and in such nature of the case, principle of equity would have no role to play, and sympathy would be misplaced. If there's any sympathy to such illegal appointment, it would be misplaced. Now, it's regarding that illegal and irregular appointment has also been defined in the case of Lalit Kumar. Difference between illegal and irregular appointment. Tell that illegal appointment is one which is done in total disregard of constitutional scheme and relevant RR thereof. Whereas irregular appointment is one where there is a substantial compliance with RR and constitutional scheme, but some provision of might have been lapses. Now, para et madam, that is the Uma Devi 5 judge constitution bench, madam. Irregular appointment cannot be regularized, but irregular appointment can be regularized. But illegal appointment cannot be regularized. This para 15, 16, 43, 45, 47, 43 and 54, madam. 53 and 54, madam. This whole sum is summarized, madam. If there's an illegal appointment, it cannot be regularized. If they can show that their appointment was irregular, then there can be the protection and the direction under Uma Devi that can be considered, that can be regularized, madam. Not against illegal appointment. It has been categorically mentioned in this paragraph, Uma Devi case. Now, again, the same 9, appointment made in violation of recruitment is illegal and such appointment does not hold any post. Even if they were working for a long time with regular pay, hence they cannot be regularized. Their appointment, regulation, whatever they are, it is not recognized under law. They cannot be treated as if they are holding the post. It does not recognize.
These are all repetition of the same principle,
My lord.
isn't it?
Yes. My lord, para 10, my lord.
All of them are the same one and the same.
Same. Only, my lord, this one, case number, my lord, 10, my lord. The Uma Devi's case, ratio test has been explained, my lord, further. Judgment of Uma Devi's case has been explained in this case. By holding that irregular appointment cannot be regularized, but illegal appointment can be regularized, my lord. In this subsequent.
You're talking the other way around.
Irregular appointment can be irregular appointment can be regularized, but
Irregular can be regularized, but not illegal.
yes, madam.
You're just saying the opposite.
In this case, madam, that the overall ratio of it has been summarized and explained that this is the whole intent and purpose of the Uma Devi's case, madam, because there has been wrong interpretation made by some of the decision that has been summarized in this case, madam. 2000 the two DAS case. Then, okay, madam, and para against 11, madam. In this case also, in case the initial appointment process itself is a violation of the constitutional scheme, no regulation can be granted, and the court cannot allow such illegality to continue irrespective of the length of time for which it has been continued. In this case, madam, the service of illegal appointees who was appointed in the year 1985 was terminated after 15 years of regularization on the ground that initial appointment itself was illegal.
after 15 years. Therefore, their length of service is immaterial matter for illegal appointment. Now, the part B is judgment on the point of law that no reversion, cancellation, or promotion would be made in violation of principle of natural justice, which is in favor of the petitioner in state case. This is Dres Chan Paul, it's a Tripura case, Tripura High Court, held that employees should not be put to suffer for any fault committed by the respondent authority, and further held that reversion of the employee's position to the lower grade is arbitrary and not sustainable in law. Even if assuming there's a certain irregularity, but its irregularity it is not in the case of illegal appointment. Even if assuming there was done in promotional irregularity has been done, this is their department have considered, they have taken into account. It was not suppressed, it was brought, and the record itself is clear. Now, if this has been done, overlooked, in that case also, for the wrongdoing of the authority, cannot be held liable to the employed who has been given benefit matter. Now, and same second is page serial case number 30, Himanta Chakmai. This is our own High Court decision of the Justice Suman Shah. There are 2, 6, and 7. Held that cancellation of promotion and reversion of the employee's position is to the lower grade without issuing any notice and without opportunity of being heard is illegal, being violative of principle of natural justice. It was the reversion order was set aside first in this case. And one Birender Singh versus Naviar, that is the division bench of the Uttarakhand High Court. There are 4, 5, 6, 7. Held that cancellation of promotion after 4 years of regular service on promotional post without issuing notice is illegal and unsustainable in law. Such action of the authority amounts to imposing major penalty which cannot be done without following due procedure. But this is why that I relied in my reply, Article 311(2) and CCS Rule 2014 that cannot this amount to imposing penalty upon me after giving me promotion, regular promotion, having held the post for the last 7 years on regular basis, they have been turned down. And regarding their contention that it has been done on the strength of OM, clause 18.1. In this regard, again, see, reliance placed on behalf of the petitioner on a point of argument that clause 18.1, the office memorandum dated so being mere guideline has no statutory force, and as such, same cannot be interpreted to negate or override the mandate of Article 311(2) of the Constitution and Rule 14 of the CCS Rule 1965. But for that matter, I have relied 2 judgments, Ajay Kumar and Javir Singh Malar. The statutory rule cannot be superseded or overridden by the administrative instruction or guideline. Second, Javir Singh Malar, the government cannot amend or supersede the statutory rules by administrative instruction. Now, statutory rules, Rule 14 of CCS Rule 1965 and constitutional provision mandate under 311 sought to be, going by their contention, it can override matter. That is this background I relied this to judgment matter.
Right.
This is my submission matter, subject to the what.
Yes, let me hear the other side.
Yes.
My lord, this entire argument, what I have, if correctly understood, there are 2 grounds of challenge. One is the challenge made to the initial appointment of the private respondents, 4 and 5, that they were illegally appointed in the year 2003 and 2004.
Yes.
First leg of challenge is that their regularization in the year 2005 is illegal also. Their initial appointment is illegal, so their regularization also way back in 2005 is also illegal. So they cannot have a march over the petitioner who has been subsequently appointed through a selection process in the year 2009. Now, and the second argument is that he being promoted from the post of SK to the post of assistant assistant survey officer, survey and settlement ASSO in the year 2016, he cannot be reverted back after 7 years, after serving for a period of 7 years. These are the two main contentions, Manoj. In the first ground, what I will submit, the petitioner, he was appointed in 2009.
2009?
2009, in the year 2009. The private respondents, they were maybe illegal, irregular. They were appointed in 2003 and 2004. And subsequently, they were even regularized in the year 2005. 2005. Now, when the petitioner entered into service, there was a provisional seniority list asking claims and objection in the year 2012. Subsequently also, there was another provisional seniority list in the year 2015. I'll just take your lordship to the advertisements in the writ petition at page 16, para 16, madam.
Is the seniority list available?
Yes, both the provisional seniority list. My lord, in para 16, the petitioner states that the petitioner begs to state that after his appointment to the post of supervisor Kanungo, the first provisional combined seniority list of survey staff of land so-and-so was published by the director so-and-so, dated 22/5/2012, inviting claims and objection against the provisional seniority list, if any, within the period so-and-so. In the said seniority list, separate seniority for so-and-so, surveyor record Kanungo, supervisor Kanungo was maintained under separate head. He has annexed that as Annexure 12. That Annexure 12 will be at page 85. In this provisional seniority list, recorder Kanungo in the page 87, my lord will see in the column of supervisor Kanungo, serial number 9 is the respondent number 4 and 10 is the respondent number 5. And the petitioner is in serial number 28 at page 88. 20 at page 20 at page 88. This is the Nakap Hina Nabang. He makes no agitation against this provisional seniority list. No claims and objection. Thereafter, at para 18, if not, we'll see at page 17. Para 18, merit. The petitioner begs to state that subsequently another provisional combined seniority list of survey staff of land management was published, white number so-and-so, dated 15/10/2015, inviting claims and objections against such provisional seniority list, if any, within a period of 45 days in the said seniority list, all working surveyor SK, RK were under combined seniority list without there being any distinction or separate heading. In para 19, he says, in response to the provisional seniority list published on dated 15/10/2015, the petitioner has submitted his representation dated 13/11/2015 through the so-and-so. So wherein he has categorically stated that the incumbent whose names reflected at serial number 1 to 17 are all illegal appointees and they have not been appointed through any selection process. Furthermore, so-and-so provisional does not have any requisite education qualification. As such, they cannot discharge the duty of technical so-and-so. In 2015, he came to know. It is his own statement that these are illegal appointees. In 2015, he makes a representation.
Yes.
But he has not approached this honorable court, saying that this challenging the appointment of this serial number 1 to 17. He has approached this only in the year 2023, after lapse of 8 years. And if we count from the initial date of appointment after a lapse of 20 years. 20 years. Initial appointment was in 2003 of the private respondent. Now, in 2023, he comes and challenges the appointment.
Yes.
Of course, illegal appointments and irregular appointments are appointments, but my lord will see whether the petitioner can have the locus to challenge it at this distant point of time. Delay in laches is also a ground for not considering the claim of the petitioner. In 2015, provisional seniority list also, private respondents, and
2012, there was a provisional.
yes,
Repeated in 2015.
yes.
Thereafter, any other list?
No, my lord. Thereafter, there is another list, but his name does not appear there. Final seniority list, because in 2016, name does not appear there because in between he was promoted as ASSO. So his name did not figure in the list of SK. Now, for that, I'll give on the account of delay in laches, I have some citations which I will place later. The second leg of argument, what my understanding has said, that he was promoted from the post of SK to ASSO in 2016. My lord will kindly see what my learned friend has read at page 120. Page 120. It is his representation. Sri Nakap Hina Nabam, SK UPA has submitted representation for promotion to the post of Assistant Survey and Settlement Officer, previously plain tabler machine. It may be informed that the present incumbent to the post of SSO, Sri Gope Kamdak, is retiring on so-and-so on superannuation. Thereby, the post will stand vacant after retirement of the present incumbent with effect from 1/3/16, which is required to be filled up immediately for planning in the district. In so far RR of the post is concerned, the post of PT now SSO is 100% promotional from surveyor of the department. My lord will kindly note, from surveyor of the department. He is a SK. However, it may be informed that the PT post has been designated as ASSO to assist DLRSO in day-to-day field and work office, which requires a person capable of dealing with field as well as office work in tandem with DLRSO. In this connection, it may be also be informed that the maximum education qualification among the serving surveyors is class 10 pass only. Therefore, it is a fit case for one-time relaxation of RR to absorb a capable official from among senior SKs. The seniority list of so-and-so is from the existing surveyors. None of the surveyors were qualified because they're class 10 pass only. So one-time relaxation of the RR was sought to absorb a capable official from among senior SKs. My lord, this is the initial note from senior SKs, since surveyor is the feeder cadre. My lord will kindly see the RR itself, what the plain tabular, which has been designated as ASSO at page 111, my lord. Annexure 17. My lord has seen. This is type copy, my lord. At page 113, 113, my lord. The name of post, plain tabular. There is only one post, my lord. Will kindly see one post subject to variation from science. Then in the next page at 114, at column 11, it is at column 10, it is 100% promotion. Then column 11, promotion from amongst the surveyor with 5 years qualifying service in the grade on seniority cum merit basis. It talks about surveyor. And within surveyor also, seniority cum merit basis. Now, in this particular case, there were no eligible surveyors.
This post of plant tabular has been converted into that
ASSO. Yes. ASSO. So his promotion to the post of ASSO should be by promotion from the post of surveyor.
But this note says that there's no such kind of availability at the present.
Yes.
So
it should, it says by relaxing the rules, by relaxing the note emphasizes by relaxing one-time relaxation of the rules from amongst the senior most SKs. Now,
relaxation is in respect of the educational qualification?
Yeah, relaxation in respect of for promotion from
SK.
From SK.
Not from surveyor.
No, surveyor, since there is no one eligible from the surveyor, so to be filled up from amongst the SKs, the
That is one thing. The second thing is it also regarding educational qualification?
Education qualification from this from the SKs, those who are eligible, senior most those who are eligible, if that be. Because even if the senior most SK is not having the required education qualification, that also cannot be filled up. Now, there was no relaxation of rules. He has been given officiating promotion without considering the senior most SKs. In the seniority list of 2015 also, his name figures far below.
Now you're trying to say that although generally it was decided that, I mean, it was proposed that consideration should be done from amongst the senior most SKs.
Yes.
They have individually considered his case.
Yes, individually, only his cases without considering the senior SKs. Now, this fact has come into knowledge that, yes, indeed, at that point of time, there were some irregularities because of which illegalities in the promotion given, because of which a junior SK tries to merge over the senior SKs. Because of this illegality, the petitioner is taking it as a stepping stone to merge over the seniors. Otherwise, his appointment is in 2009. The private respondents were regularized in 2005 itself, 4 years ahead of them, in the post of SK. That, my lord, will see at page 130. This is how the petitioner was given the promotion. The departmental promotion committee constituted by so and so, comprising of the following for promotion of Sri Nakap Hina Nabam, who is officiating in the post of Assistant Survey and Settlement Officer, Government of so and so. Only his case. He was initially given officiating and only his case was played. The department had placed the relevant documents pertaining to the post of so and so SSO plant tabler. As per materials produced by the department, the lone post of ASSO is lying vacant following retirement of Gope Kamdak, who retired on so and so on 29 February 2016, and once Sri Nakam Hina Nabam has appointed on officiating basis in the post of resultant vacancy. DPC is to examine the service book, ACRs, and other relevant records of Nakap Hina Nabam with the proposal to promote him to the post of ASSO and also to regularize his officiating. The DPC has examined the required particulars of the incumbent relating to ACRs, APSRs, dossiers, NOC, vigilance clearance, and are found to be in order except seniority list since Sri Nakap Hina Nabam was already officiating in the post of AS and SO, and his name has been taken out, omitted from the seniority list of Supervisor Kanungo by the department. Only his case, without considering the case of. Now, one post of table planner or ASSO, that also has to be done as per the rules, and the rules says as per by promotion, 100% promotion from the post of surveyor by seniority come merit. It talks about first surveyor, the feeder cadre should be surveyor, and the second condition is it should be by seniority come merit. Now, in this case, the first condition that he is a surveyor, that also is not fulfilled. The second condition, seniority come merit, also has not been considered. Now, because of this promotion, illegal promotion, when it came to notice of the authorities, yes, there was some illegalities committed. The seniors were not considered. A review, DPC has been sought to be, there is a review DPC conducted. And therefore, his case has been reverted back. Because of this illegality which he got in the year 2016, he tried to merge over the seniors. My lord will kindly say the next promotional post is the post of District Record and Settlement Officer, DLRSO. The recruitment rule is at page 26. This is all his challenge to the initial appointment of the private respondent. He has never earlier challenged it. Only because he has been reverted and the private respondents are going to merge over him, he is now trying to challenge the initial appointment of the private respondents. Now, the recruitment rule of 2006 at page 136, this is the post of the Land Revenue and Settlement Officer. My lord will see is selection so and so, so and so. And then at page 139, method of
Revenue segments.
yes.
This has been redesignated.
No, my lord. This is
LR,
The land revenue is redesignated.
redesignated as district.
Land revenue.
DLRSO.
Yes. Earlier it was
Just district.
District
No,
has been-
it was Land Revenue Settlement Officer.
yes.
Then district was added.
Yes, ma'am.
Hmm.
At page 139, it is the column method of recruitment
8 years.
139, column 11, in the top heading, method of recruitment, whether by direct recruit or by promotion or by deputation, transfer and percentage of the vacancies to be filled by various methods. A, 50% by promotion and 50% by direct recruitment on the basis of APPSC comment so and so. Then in column 12, this was by promotion from amongst plain tabler, surveyor, record kanungo, supervisor of the department who have rendered 8 years of regular service in the grade so and so, and following class 12 pass, certificate course so and so. But this column 12 has been amended, my lord. Now the amended portion, as per the at page 140.
5 years now.
In column 12, my lord will see serial number 6. In column 12, for the existing entries, the following shall be substituted by promotion from amongst. Assistant surveyor and settlement officer now designated from plain tabler by so and so, who have rendered 5 years of regular service in the grade. Then surveyor who have rendered 11 years of regular service in the grade. Then C record kanungo, supervisor kanungo who have rendered 15 years of regular service in the grade and possessing following education qualification, graduation or bachelor degree in the discipline from a recognized university, undergone certificate course in so and so from a failing which by transfer on deputation. Now all the private respondent as well as the petitioners, they are claiming for promotion to this post. When DPC was sought to consider the cases, then it has been found out the petitioner, who was far below in the seniority list as SK, has merged over the seniors because of an illegal DPC for the post of ASCO in the year 2016. Now, after coming to know that a review DPC has been constituted, that has been rectified, he has been reverted back, and the private respondents have been recommended. Now, the contention of the petitioner that by way of a DPC, he cannot, without giving him opportunity of hearing. That comes a later stage. That a so-called notice will also be given, that why you should not be reverted back. That is a subsequent action. He will be given that opportunity that why your promotion, earlier promotion should not be taken back. Why should you not be rewarded? He will also get his promotion when he becomes eligible, but not by taking advantage of an illegal DPC. He cannot have a merge over the seniors by an illegal order. But therefore, prima facie, he was not eligible to be promoted as the ASSO. And therefore the authorities are always at liberty to have a review decision to correct the mistake. If something has gone wrong, something was done wrong, it is the authorities will always have the power to rectify it by way of a review decision. He will be given, obviously be given an opportunity that we are going to revert you. But that will follow. Before
that stage has not come.
Yes, that will follow. Before that, he has approached this honorable court. Now, therefore, the first leg that of his ground that the appointments of the private respondents are illegal or irregular whatsoever, my respectful full submission will be that the petitioner has not challenged their appointment at the earliest given point of time. By this time, when third-party interests of the private respondents have accrued, the petitioner cannot, this honorable cannot entertain a petition to give relief. When already, because of the delay in laches of the petitioner, third-party rights have accrued to the private respondent. To that effect, I have two small citations, my lord. 2011, 5 HCC.
Sorry.
Correct to be there.
इसको भी ले लो तो रिलाई कर ले Please, you have done it. You go first.
2011 5 SCC 607. Only one paragraph, my lord.
Regarding third party right?
Regarding delay in laches.
Oh, delay in laches.
2011 5 SCC 607. Para 45, my lord. Oh, 54. Para 54, sorry, ma'am. Para 54.
Yes.
The relevant consideration in determining whether delay or laches should be put against a person who approaches the writ court under Article 226 of the Constitution is now well settled. They are: 1. There is no inviolable rule of law that whenever there is a delay, the court must necessarily refuse to entertain the petition. It is a rule of practice based on sound and proper exercise of discretion, and each case must be dealt with its own facts. The principle on which the court refuses relief on the ground of laches or delay is that the rights accrued to others by the delay in filing the petition should not be disturbed unless there is a reasonable explanation for the delay, because courts should not harm innocent parties if their rights have emerged by the delay on the parts of the petitioners. Thirdly, the satisfactory way of explaining delay in making an application under Article 226 is for the petitioner to show that he had been seeking relief elsewhere in a manner provided by law. If he runs after a remedy not provided in the statute or the statutory rules, it is not desirable for the High Court to condone the delay. It is immaterial what the petitioner chooses to believe in regard to the remedy. Number 4, no hard and fast rule can be laid down in this regard. Every case shall have to be decided on its own merit. The representation would not be adequate explanation to take care of the delay. This is one. And the second judgment, Vijay Kumar Kaul and others, my lord. This is a small judgment. 2012 7 SCC 610. Para 23 onwards, my lord. 23 to 27, my lord. These are small paragraph, my lord. Reiterating other judgment. This is also with regard to service seniority. It is necessary to keep in mind that a claim for seniority is to be put forth within a reasonable period of time. In this context, we may refer to the decision of this court in so-and-so, wherein a two-judge bench has held. It is not that there is any period of limitation for the courts to exercise their powers under Article 226, nor is it that there can never be a case where the courts cannot interfere in a manner after the passage of a certain length of time. But it would be a sound and wise exercise of discretion for the courts to refuse to exercise their extraordinary powers under Article 226 in the case of persons who do not approach it expeditiously for the relief and who stand by and allow things to happen and then approach the court to put forward stale claims and try to settle matters. 24. In Karnataka Power Corporation Limited versus so-and-so, the court held thus that delay or laches is one of the factors which is to be borne in mind by the High Court when they exercise powers, exercise their discretionary powers under the Article 226 of the Constitution. In an appropriate case, the High Court may refuse to invoke its extraordinary powers if there is such negligence or omission on the part of the applicant to assert his right as taken in conjunction with the lapse of time and other circumstances causes prejudice to the opposite party. Even where fundamental right is involved, the matter is still within the discretion of the court as pointed out in the so-and-so. Of course, the discretion so exercised shall be judicially and reasonably. Then to para 25, in city so-and-so, this honorable court opined that one of the grounds for refusing relief is that the person approaching the High Court is guilty of unexplained delay and the laches inordinate delay in moving the court for a writ is an adequate ground for refusing a writ. The principle is that the courts exercising public law jurisdiction do not encourage agitation of stale claims and exhuming matters where the rights of third parties may have accrued in the interregnum. From the aforesaid pronouncements of law, it is manifest that a litigant who invokes the jurisdiction on account of invokes the jurisdiction of the court for claiming seniority, it is obligatory on his part to come to the court at the earliest or at least within a reasonable span of time. The belated approach is impermissible as in the meantime, interest of third parties gets ripened and further interference after enormous delay is likely to usher in a state of anarchy. The acts done during the interregnum are to be kept in mind and should not be lightly brushed aside. It becomes an obligation to take into account consideration the balance of justice and injustice in entertaining the petition for declining it or on the ground of delay in latches. It is a matter of great significance that one point of time equity that existed in favor of one melts into total insignificance and paves the path of extinction with the passage of time. My Lord, I'll make a small submission here. My Lord, challenges made to illegal appointments were being made on the background that we are also eligible. Why depriving us? You are being appointed, Mr. So-and-so is being allowed. It is violation of Article 14 and 16. I also have the same qualification. I am also eligible. I also want to participate in the selection process. So without there being a selection process, why the state is appointing so-and-so without there being any advertisement? Challenges are made on that ground. A person who is unemployed having everything equivalent when he is deprived. This is the basic constitutional scheme that I am deprived of Article 14 and 16. Challenges to the illegal appointments, my Lord will remember that initial all challenges. Why backdoor entries? Those are done by the unemployed youths who have the equal qualification and zeal for public employment, those who are deprived. Now, in this particular case, saying that illegal by the petitioner, that these private respondents were illegal, they were illegally appointed. At that point of time, whether the petitioner himself was qualified. No other person has questioned their entry into the service. No other person has challenged their appointment. Whether the petitioner, even assuming at that point of time, 2005, when the services were regularized, whether the petitioner was eligible. And at the time when he got selected through a selection process in 2009, at that point of time also, when he came to the department and saw that earlier his seniors have been appointed through backdoor, why couldn't he challenge at that point of time? In fact, in his own representation in the year 2015, he says that these are backdoor entrants. Now, 2015 also, I say, at that point of time, if he challenges, that I came, as per the seniority list, I came to know that these are illegal appointees. He did not challenge their appointment at that point of time, also, even in 2015. Forget about 2005, forget about 2009, 2012, and 2015. Now, just because he has been reverted back, now he comes up that his initial appointment was, their initial appointment was illegal. This is not a ground explaining the delay in HS. In fact, this is a reason that because he wants to merge over the seniors, now he has no other option but to challenge their initial appointment, which was done long way back, which he kept silent. This cannot be allowed. Had the petitioner been left, kept senior to the private respondent, he would have never challenged it. He would have let the petitioners enjoy, or let the private respondents continue. It is only because now he cannot merge over his seniors. Now he has no other option but to challenge the initial appointment, which is therefore time barred. There are enough delay in latches in between the private respondents have further got promotion as ASOs.
Two promotions.
Promotions. Now, in respect of the other contention that I've already stated, as per the RR, it is for the post of plain tabler. It is to be by way of.
Before that, are you going to refer to this Ajit Singh and others?
Yes.
This is also on delay.
Yes, same. Ajit Singh too. That is 1919.
This is delay only.
My lord, I have given Vijay Kumar and one is Sankara Cooperative Society, Cooperative Housing Society Limited.
Yes. Shankara Cooperative you've given, then Vijay Kumar. Then what is one more? Ajit Singh.
Yes, Ajit Singh, my lord. Ajit Singh is on the this point, not on the delay in latches. Ajit Singh is for the subsequent. Here, my lord, as per the order of the ASSO, the requirement is 100% by promotion and from promotion amongst the surveyors, and that too by way of seniority come merit.
Equal opportunity.
Equal opportunity.
To all.
Here, para 23, I'll directly come to para 23. Equal opportunity. Why should the seniors be left out? Why alone the petitioner have been considered at that point of time? No matter he is eligible, but why seniors should be left out? That is the basic contention. Where promotional avenues are available, seniority becomes closely interlinked with promotion, provided such a promotion is made after complying with the principle of equal opportunity stated in Article 16(1). For example, if the promotion is by rule of seniority cum suitability, the eligible seniors at the basic level as per seniority fixed at the level and who are within the zone of consideration must be first considered for promotion and be promoted if found suitable. In the promoted category, they would have to count their seniority from the date of such promotion because they get promotion through a process of equal opportunity. Similarly, if the promotion from the basic level is by selection or merit or any rule involving consideration of merit, the senior who is eligible at the basic level has to be considered, and if found meritorious is in comparison with others, he will also have to be promoted first. If he is not found so meritorious, the next in order of the seniority is to be considered, and if found eligible and more meritorious than the first person in the seniority list, he should be promoted. In either case, a person who first promoted will normally count his seniority from the date of such promotion. There are minor modifications in various service in the matter of counting seniority or so and so, but in all cases, the senior-most person at the basic level is to be considered, and then the others in the line of seniority. Here, he was far below in the seniority list as SK. All picked up. No relaxation in the RR. Even the note sheet which was initiated also talked about relaxation in the RR. There was no relaxation in the RR also. And only the case of the petitioner was considered. Because of that illegal promotion, he tried to have a march over his seniors. Now, when he's reverted, after delay of more than 20 years, he is now coming and questioning the very initial appointment of the petitioners, private respondents. That is the reason. There is enough delay in latches. No explanation. That's all, my lord.
I might take some time. I have some citations to place. Other friends are also waiting.
We do one thing, we have it maybe on Wednesday.
But that's fine.
Tomorrow there'll be DB and I think I have some other matter. So
Fine,
Wednesday we'll take it up.
fine. I'm for the R5 and
You are R5 and
R4. I'm for
R4
R4 and R5.
Parvez for R5. And Mr. Tagum will reply. That much is left. Okay. I think basically you'll all adopt what Mr. Ratan has said.
Supplementing 2 points I have.
Okay.
Other friends are also waiting.
All right.
We will be giving a rejoinder. Yes. Through you, my lord, may I request my brother Tagum to provide us the list of citations which he has submitted. No. So normally we give it. No issue. I can ask them. No.
You already have it in the computer. Mr. Tagum.
Yeah.
You have nicely taken out the paragraphs and all that.
Yes, no issue.
I think our two pages, you just take a printout and give it to them.
Only the
Books they'll have.
initial 2, yes. Yes.
Books and all those things they have. Only that
2
those
pages.
2 pages you have to give them. That's all.
My request is my brother even did not mention the citation number. He did not read out. So we missed the bus. Which citation he was right to.
No, he'll give. Mr. Tagum is fair otherwise.
But he's a good gentleman.
Okay, hard in part. List again on Wednesday.
Obliged, man.
Orders tomorrow anything happens.
That's an interim order.
Yes.
Okay, interim order, first list to continue till then.
Item number 7.
My lord, item number 7, I am appearing virtual, my lord. Am I audible, my lord?
Okay. Just a minute.
My lord.
Let the file come.
My lord.
Yes, 7.
Time mangga na. Abang search lagi na.
My lord, this this matter pertains to a land acquisition, my lord. So what happened here was, my lord, we have filed an objection before the collector, my lord, before the collector. Now the collector, instead of referring under section 64 of the Law Act of 2013, directed us to go to the civil court, my lord. And my lord, there is a jurisdictional bar on the civil court, statutory bar on the civil court. Civil court ultimately disposed of our civil suit, my lord. And thereafter, my lord, we went to the authority, my lord, because if under section 64, if the collector refuses, that we can invoke the provisions and go directly to the authority. Now, what the authority did was, my lord, he has given back us, he has directed us again go back to the collector file, and then the collector decides in accordance with law, which was wrong, my lord, which is absolutely wrong, my lord. So therefore, my lord, is a very short question, my lord, that we are before, my lord, that our petition, that is section 64 applications that is pending before the authority, my lord, should be taken up. Because, my lord, you will see section 64 for a moment, if my lord.
Yeah, what is section?
May your lordship? Your lordship, this matter may be adjourned, your lordship. In this matter, Irish Nabom AAG is appearing. He just left the court due to some personal problem.
Okay, we'll adjourn it, but let us see the section 64.
Yes, my lord.
The Lara Act 2013.
In the meantime, may I read, my lord, section 64?
Yes.
Section for reference to authority, subsection 1, any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred by the collector for determination of the authority, as the case may be, whether his objection be to the measurement of the land, the amount of compensation, the person to whom it is payable, the rights of rehabilitation and resettlement under Chapter 5 and 6, or the apportionment of the compensation among the persons interested, provided, my lord.
Okay, this is like the old Act, Section 18.
Yes,
reference.
yes, all like Section 18,
Mhm,
exactly, my lord. So proviso is here, my lord, provided that the collector shall, within a period of 30 days from the date of receipt of the application, make a reference to the appropriate authority, provided further that where the collector fails to make such a reference within the period so specified, the application may apply to the authority as the case may be, requesting it to direct the collector to make the reference to it within a period of 30 days, my lord. So, my lord, here I file an objection before the collector first, my lord, and saying that this is our land, there's a subject dispute. Do not pay to the land affected areas because those are the bogus name, my lord. They don't have the right. But instead of referring the matter, he directed us to go to the civil court, my lord. Now, my lord, here the clients are, my lord, illiterate, doesn't know the provisions of law. And there was...
what was, Mr. Counsel, what was the ground of your objection?
No, the ground was of our objection was that we were objecting...
It is your land.
Yeah, it is my land, my lord. It is my land. And some of the names that has appeared as a land affected families, my lord, they are not entitled to get because they do not belong to, it doesn't belong to them, my lord. It doesn't belong to them. There's no
So
objection.
your cases of that, of the apportionment.
Is that
Apportionment.
not of the yeah, of course it's an apportionment, but particularly, my lord, it says here objection to the amount of compensation the person to whom it is payable, my lord. But specifically my case lies there because I'm saying that this compensation is not liable, is not to be paid to certain individual.
Yes.
To certain individual, my lord. So therefore, my lord,
Yes.
if this objection is raised, the collector is duty bound, under statute duty bound to refer the matter to the authority to decide, my lord. So this was not done.
So instead you have been relegated to the civil court.
Yes, yes, to the civil court. But
Then
rightly,
what happened to that matter then?
no, in the civil court, my lord, rightly or wrongly, we went to the civil court, and the civil court finally disposed of the matter by saying that because there is a statutory bar. I cannot entertain because it's a subject matter of land compensation under the law.
It was not disposed of on merit. It was on
It was
the
not disposed
technical.
on merit. It was disposed on jurisdiction, on the point of
Okay,
jurisdiction. Then, my lord,
thereafter.
Then thereafter, my lord, we approached the proviso. As per the proviso, we approached directly to the authority under Section 64, my lord.
Yes.
Then under Section 64, now the authority, my lord, did not decide. But however, my lord, directed us to go again to the collector. May I just take my lord to...
Yes.
So we have been, my lord, we have been pushed around, my lord, from one corner to the another corner. That is the reason why, my lord, we have come before my lord. With a limited prayer, my lord, there is another prayer, but we're not pushing to that point whether the acquisition proceeding has lapsed or not. We are not pushing that anymore, my lord, because that will that's not going to serve anyone's purpose, my lord.
So you went to the civil court. Civil court says that I have no jurisdiction. Then you go direct to the authority. The authority now says that you go to the collector.
Yes, my lord.
And that's why you're here.
That's why we are before my lord.
Where is any order has been passed by the authority or any?
Well, the authority's order, I'll just take my lord to the authority's order. It's at, that's page, 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 annexure 16, my lord, that's page 116.
116.
Yes, my lord.
This is the court of district judge.
Yes, my lord, my lord. He's the authority, my lord. The order, my lord, may I read from the second paragraph, my lord?
Yes, please read.
Yes, my lord. Learned counsel for the petitioner has submitted that the case has been filed as a reference under section 64 of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, Resettlement Act of 2013 as a Deputy Commissioner Rowing rejected the representation dated 20th of March 2021 and 16/04/2021. The petitioner is required to submit appropriate application before the collector cum Deputy Commissioner Rowing for reference under section 64 of the Act. The Learned Counsel for prays to withdraw this case with a liberty to file appropriate application before the collector called Deputy Commissioner Rowing. Learned Counsel for the reference has no objection to withdraw this case. The petitioners are at liberty to submit appropriate application before the Deputy Commissioner cum collector, and the same shall be decided in accordance with law. It is needless to say that the learned Deputy Commissioner Rowing shall decide the application of the petitioner as per section 64 and section 65 of the Right to Fair Compensation and Transparency in so with this, the instant operation disposed of. Now, two things here, my lord. There's a word that has been put on the council, my lord. One says that there's a liberty, my lord. And the second clause here is, my lord, the second clause here is, it says that the petitioner, as per the Deputy Commissioner, shall decide the matter as per 64 and 65 of the Right to Fair Compensation Act, my lord.
Yes. So,
my lord, here you cannot, there's nothing for the Deputy Commissioner to decide. Section 65, my lord, if you can, if I take my lord to section 65 for a moment, my lord.
now, this order was passed after the collector, the deputy commissioner has relegated you to the civil court.
Yes, my lord. Yes, my lord.
Was any order passed by the deputy commissioner?
Yes, my lord. The deputy commissioner's order. I'll take my lord to the deputy commissioner's order.
Is it 114?
That's the. My lord, that's page 105, my lord. 105.
105.
Yes, my lord. Annexure, may I read, my lord, the order?
Yes, read.
Whereas the office has been in receipt of a complaint dated 30/03/2021 and 16/04/2021 from Shri so-and-so pertaining to lodging a complaint on behalf of Mayapar clan against the area pertaining to Ilohi River and Talo so-and-so. And the claim put forth is that the area has been shown as Ilapra, Ilohi, and Mimi Sango for the purpose of acquisition for Dibang multi-purpose project. Whereas this, there has been no reference to area term as Mini Sango in the acquisition process, and the claim of acquisition of land claim as Ilopra Ilohi was taken up as part of the land acquisition process so-and-so in the matter of sub judice. Whereas the claim put forth parties to matter of title ownership of land for which an award has already been made by the Deputy Commissioner Lower Dibang Valley in respect of Dibang multi-purpose. And now, therefore, the matter is disposed of with the liberty to the petitioners to take up the matter in competent civil court to decide any issue pertaining to title ownership of the land.
So the understanding was that there's a dispute regarding title ownership of the land.
Yes, my lord.
That's why you have been relegated.
Yes. So, my lord, here what the understanding of the Deputy Commissioner was that there was a title or ownership pending But what our complaint was that there are certain names which has appeared in this particular list, my lord, which we said that they don't they are not entitled to be paid. Therefore, please refer this matter. They could have referred the matter to section relegated to section 64. That is a correct procedure, not to, because now this comes not an ordinary a suit of declaration, right of title and ownership. It's a subject matter of acquisition.
Okay. So anyway, today Mr. Nabam is not here.
My lord.
Arish Nabam.
Yes, Your Lordship.
So you were there for?
Respondent, private respondent.
Okay.
My lord, if that be the matter, may I pray, my lord?
To whom the compensation amount has been paid, Lordship, already been paid, Lordship. We
you have received the
already we have received the amount.
Okay.
And they have approached, in fact, this acquisition took place starting from 2011. They started hesitating in the year 2022 only. After every process was completed, Lordship. And their claim was for some other lane, Lordship, not in our lane, Lordship. Suddenly, 2012, they started hesitating.
All right. Anyway, this will take some time, and Mr.
It will
Nabam
take
is
some
not
time
here.
to make the things understood, Lordship.
Can we have it sometime next week then?
My lord, may I pray for either 23rd or 24th, my lord? Because I'm as outstation, I would like to come.
Lordship,
You'll come personally and appear physical.
Yes, my lord. Yes, my lord. 23rd, 24th, 25th, any day, my lord.
What do you suggest?
Lordship, we don't have any issue, Lordship.
No, okay, Your Lordship.
Monday itself, I think Monday.
Monday.
So
Yes,
that
my lord.
can spill over to the next day also will be good.
Yes, my lord. Then
As
23rd, my
agreed,
lord.
please, right? As agreed to by the parties. No, you write like this. The parties are represented by the respective councils, and the learned counsel for the petitioner appears through RVC. It is submitted that pleadings are complete and the matter can be taken up for admission hearing. Stop. As agreed to by the parties, let the matter be listed on 23rd of March for admission hearing. All right. Any other case?
Yes, there are 9 remaining. Item number 17.
17. 17. Who was there for 17? Pages.
May it please your lordship.
Yes.
This matter is regarding compensation. My lord, on last occasion, this honorable court directed learned government advocate to obtain instruction and relevant records from a respondent authority.
Yes, Your Lordship. Indeed, Your Lordship. I may be granted some more time, Your Lordship.
You want some more time?
Yes, Your Lordship.
Mr.
T. Tunka. T. Tunka.
T. Tunka, learned counsel appears for the petitioner, while Mr. Wairiram, learned government advocate appears for the state respondents.
Your Lordship, I'm appearing on behalf of learned BSCI, Mr. M. Kato, for respondent 5.
And Mr.
T. Meto, Your Lord.
T. Meto appears for Mr. M. Kato, learned DSGI, who represents the respondent number 5.
I'm appearing on behalf of RCPI, standing counsel for the Highway Department, respondent number 4.
Okay. Mr. Ibam, learned counsel appears on behalf of Mr. R. Saikia, who represents the respondent number 4. So Mr. Rira, learned government advocate, submits that he's yet to receive instructions and prays for the
2 weeks time.
2 weeks time to receive instructions. in terms of the court's order dated 12/2/2026. List again after 2 weeks.
Much obliged.
Item number 18 and 19.
This is all this.
Your Lordship,
Uh,
here we have,
Why is
we
it?
need to file counter affidavit, Your Lordship, so at least 2 weeks time may be
Oh, you
granted.
have not filed.
Yes, Your Lordship, it's almost ready, Your Lordship.
My lord. On 23rd, my lord.
You want a date?
Yes, my lord.
Okay, Your Lordship.
Ms. P. Pangu, learned government advocate, submits that the counter affidavit is under preparation and she'll be able to file it within the next
Within 2 weeks, my lord.
Within 2 weeks, Your
next
Lordship.
2 weeks.
Yes.
Mr. M. Kato, learned counsel appears for the petitioners. As agreed to by the parties, list again on 23rd of March.
My lord. Deep
Your Lordship.
Item number 20.
May I please, Lordship?
Yes.
My lord, as per last order, my lord, they have respondent number 5 has to file their counter affidavit, my lord.
No counter.
I think, my lord, they have filed today.
Yes.
Okay.
Oh,
Your
yep.
good name?
M. Sora.
M.
Sorai.
M. Sora, learned counsel appearing for respondent number
5.
5 submits that she has filed the counter affidavit today. So since the counter affidavit is not yet connected to the records office to verify and connect the same. List the matter again when?
After a week.
After a week.
Well,
Want to
let's
file a
see.
reply?
No, madam. Let it do adversary.
All right.
Obliged.
Item number 21.
My lord, may I, respondent have filed affidavit in opposition, so I may be allowed to file rejoinder for the 3 weeks time may be given.
Okay. As paid for, petitioner is granted 3 weeks time to file rejoinder affidavit in response to the affidavit in opposition filed by the respondents. List again after 3 weeks.
Item number 22.
Same matter, my lord. Same matter.
Similar order.
Similar matter. Much obliged.
Item number 23.
Yes. Arbitration petition.
My lord, as per the instruction of the department, my lord, we want to file, my lord, the reply at least, my lord, in arbitration. My lord.
Reply?
Yes, my lord.
Okay.
Affidavit in opposition, my lord.
Okay. Mr. M. Kato, learned DSGI, appearing for the respondents.
My lord.
Praise for and is granted. How much time?
My lord, 3 weeks time, my lord.
3 weeks time to file the counter affidavit.
My lord.
List again after 3 weeks.
Deeply obliged.
Item number 24.
Good evening, my lord. My lord, I am appearing in person against my own case. This case is of termination of my service. My lord, they have already been given 3 dates, and from the past 3 dates, they are just taking date after date to submit the notice reply.
Your Lordship, now it's third time I'm seeking an adjournment for the matter for filing
3
of.
days or 3 dates?
3, yes,
3
sir.
dates.
Yes, 3 days have already been passed, sir, and they are still asking for more time. My lord, my service, firstly, they have not done any inquiry. Please let me explain, my lord. Firstly, they have not done any inquiry.
No, I hope you understand what I'm saying.
Yes, sir.
You said days or dates?
No, they have
3 dates.
3 dates. Yes, yes,
Okay,
dates.
not days. I
Yeah.
heard days, that's why.
Sorry.
DAYS, 3 days.
My lord, please give me 2 minutes, my lord. I have
Yes.
something to say.
Sure.
Firstly, they alleged me of a fraud amount of 93,000.
Who are you, by the way? You work as what? You work as
Assistant manager in Arunachal Pradesh Rural Bank.
rural bank,
Yes, sir.
assistant manager.
Yes.
You have been removed.
Yeah.
Okay.
They alleged me of a fraud of 93,000. If they, even now itself, if they prove me just 1 rupee fraud, I'm going to take this matter out. They have not done any inquiry. They have not done any investigation. And when I asked them with the RTI reply, here itself in the writ petition, I have attached it. Then they are saying that the third party enclosures cannot be done. My lord, they are the first party who have taken the decision. I'm the one who have been alleged. Who is the third party here? No one. And when I asked, when I came to the court, now they are taking date after date. My lord, I am also appearing for some other exams for which I need the NOC experience letters and objection certificates. And the final thing is the reinstatement of my service. Because my lord, when I go there,
How long did you work?
almost 4 years, my lord.
4 years.
Yeah.
As assistant manager.
Yeah,
rural-
assistant manager.
rural bank.
Rural bank, yes, sir.
Where in Itanagar?
Actually, posting places have been changed, but
okay.
yeah, but when I was terminated, I was in the bank itself, Naharlagan itself.
So what you're saying is that without any process.
Without any inquiry, without any,
Without
yes.
any inquiry, they have removed you.
Yes, and when using the RTI, when I asked that how come this 93,000 have come from?
Okay. Can you show me the removal order? Where's the page?
So 1 minute. It's in
3425.
1 second.
Why you don't want to engage? Why have you not engaged a counsel?
Sir, actually I engaged, but in the meantime, I changed the lawyer. So this date was very sooner, and so I told him that I will appear in person for this time itself. But for the final argument, I will definitely engage the other one.
3425.
The termination letter, firstly, and my lord, SOCO's notice in the 52 and 53 page number.
No, termination.
Termination.
30. So Shokos was given.
Termination letter is page number 66 and 67.
Shokos was given to you then, if you are saying so.
Then I replied to it. And my lord, I agree that my reply was not so effective because at the time March ending was there. But in the after termination letter, we have to appear for board of directors. Means we can file our this reply to the board of directors. But the thing is that board of directors, appellate authority is also the chairman who have terminated me. So bias decision could easily become coming.
So you have not filed an appeal.
Yes, sir. I filed the appeal, but appeal letter is also here. But the thing is that a board of directors, appeal goes to the board of directors, and the appellate authority of the board of directors is also chairman. Again, they terminated me in the month of September 30. Effective from, sir, actual termination was from May, but after board decision, termination letter was again issued on September 30. Board decision is on page number 105 and 106.
Page 67 is the termination order, is it?
Yes, sir. Yes, sir.
Board means what board decision?
Board means, sir,
The appeal.
After termination,
You
we
file an
can,
appeal.
yeah, we can file the appeal.
And where is the order decision?
Page number 105, 105.
105.
And they have not submitted me any my notes what was presented in the board. Simply, the chairman itself has signed and said that the board has kept my decision and you are still terminated. Go.
You were saying that no proceeding was drawn against you.
Yes.
Then you have given your reply also.
Yes.
Any show cause given to you?
Yes, my
Show
lord.
cause
It was-
notice, explanation?
It is on page number 52 and 53.
52. After this, what happened?
I gave the SOCOS notice reply.
Then, thereafter?
Thereafter, they terminated me. No, any inquiry was done. Some kind of purported.
Are you on probation?
No, sir. Actually, I completed the probation, but they have not given me the confirmation certificate also. On January itself, I have completed, but my lord, in the termination letter, actual terminating me, the actual thing lies in the fraud amount, not the probation.
Of course.
Yeah.
Probation, you can be terminated during your probation.
Yes.
It's a termination simpliciter.
But
Normally.
yes,
But
ma'am.
in your case, you're saying that it is because some allegation was
Yeah.
made that you had fraudulently misappropriated this amount.
Yes, yes, my lord.
It is for this reason they have been removed.
Yes, my lord, in page number 66, if you could come.
66 years.
One second.
You had given this as a loan amount over.
My lord, in page number 67, they simply have said fraud amount of 93,000. The effective thing lies in the fraud amount itself. And I am saying that not a single rupee fraud has been done by me. In fact, they have deducted the amount from my salary and still terminated me.
All right. Anyway, we'll have to give them some more time.
Yes, your lordship.
My lord, I'm just saying that
This
I'm a,
requires some
my lord, please let me say, I am also appearing for some other exams. Because my lord, I am still having some age to apply for those exams. And recently, SBI CBO exam, I cracked the mains, but I can't sit in the interview just because I was not having the NOC and the experience letter. Now I simply want a particular date, my lord, any date if you wish. I want to have the argument. Because 3 dates have already been passed, 3 months have been passed.
One thing you have to understand also is this impugn order of termination, isn't it? Or removal or termination?
Yeah.
It's a termination.
Yes. Yes, ma'am.
Now, whether this will bar you for future employment or whether it will not bar you.
My lord, I don't want to carry that stigma in my future because if I have not done anything.
No, see, you're not trained in law, you see.
Yeah.
We have 2 types of, I mean, apart from many other things, there are 2 types mainly. One is removal from service. One is termination from service.
Okay.
So supposing you're terminated from service, will it amount that you are not debarred from future employment? Or it is a termination from service without any bar for future employment? So that has to be first, you know, like...
No, actually, I went through it. Actually, they are not debarring me from future employment. Means that the clause that they have mentioned 9A, it doesn't debar me from the future employment.
Okay.
But I want to get reinstated, my lord, because I don't want to carry this stigma, and I want a fixed date. I'm ready to have the.
Yes, you're a standing counsel.
No, your lordship. I'm appearing on behalf of Teto Taba, standing counsel.
Who's the counsel?
Teto Taba.
Teto Taba. Where
Yes,
is
your
he?
lordship.
He has not come today?
Yes, your lordship.
My lord,
Since some difficulties, he's absent. Also, we, lordship, 1 week time may be given for filing of the affidavit because we would like to file the affidavit.
Definitely. You
Yes.
file the affidavit, you produce the records also.
Yes, your lordship.
See, one thing, when was the first time the matter was taken up?
It was taken on 5/1/2026.
5/1.
Yes, your lordship.
5th January.
Notice was issued or not?
Yes, sir. It was issued on the same day itself. Actually, I inquired with the lawyer who came that day on behalf of me. They said that the standing counsel came a little bit late and they gave the notice on that day itself.
Please write down. The petitioner appears in person. And submits that he's agreed with the order by which he has been terminated from service. And also the order passed by the appellate authority confirming the termination order. So he submits that due process has not been followed in passing the impugn orders. And in fact, he is innocent of the allegation that has been made against him. To stop. He also submits that since he is still in the age group to seek further employment, there is urgency in the matter. Your good name, Miss?
N. Hondik, your lordship.
Miss N. Hondik.
Yes, your lordship.
Learned counsel appears on behalf of Mr. Teto Taba, who is the standing counsel for the, what bank is this?
APRB, your lordship.
Arunachal Pradesh Rural Bank.
Pradesh Rural Bank.
Arunachal Pradesh Rural Bank. He represents both the respondents?
Yes, your lordship. And it's
And who represents both the respondents? And submits that she may be given
1 week time.
a further
1 week.
7 days time to file counter affidavit.
Yes.
Since the bank wishes to file counter affidavit. Next para, considering the above submissions made and the urgency expressed, let the matter be listed. I will give you more than 1 week, okay?
Okay, Your Lordship. And
Because you
it's the
have to
third time we are
organize-
appearing, Your Lordship.
Sorry?
Actually, it's the third time we are appearing in this matter, Your Lordship.
It's okay. Sometimes you file affidavit in the first appearance also. We don't.
My lord, can I get argumented, my lord, before that, if they must submit that reply?
No, that's what we're fixing a date. Which date would be convenient?
And any date in that month, because they are asking for just one day,
I'm
1 week.
asking her first. Let us choose a date so that they file it. Today's 9th. You wanted a week, but we'll give you more than a week. You choose a date.
20 or something.
How about 24th?
Your Lordship.
It's a Tuesday.
Yes, Your Lordship.
And you would file the affidavit on or before 20th of March.
Yes, Your
Okay?
Okay, Your
That
Lordship.
means you have enough, at least 2 weeks time.
Yes.
Okay.
And my lord, if not given, then declare the matter as ex parte, please. Please, my lord. Again, they will come and again ask for more date, my lord.
No. What did I say last? Express, list the matter, cancel that. The respondent bank shall file the affidavit of position on or before 20 March 2026. And the matter be listed on 24th of March 2026. On which date an endeavor shall be made to dispose of the case.
Thank you.
The respondent bank shall also produce all the relevant records leading to the termination of the petitioner for perusal of the court. Okay.
My lord, I just want to ask that on 24, can we get a date of argument? Just I'm asking because I'm not aware of it. On 24, for example, this is going to be listed again.
Yes.
So on that day, can we get a date of argument?
24th is the date of the argument.
Oh, argument. Thank you, sir.
You will get the affidavit of position by 20th of March.
Okay.
You go through it.
Okay.
And 24th will be the date of the argument.
Thank you.
But if you say that since I find something in the affidavit, I want to reply.
No, my lord, I know.
Then you may take some more time.
Okay, my lord.
But if you don't take time, it'll be heard on 24th.
Thank you, my lord.
And they will produce the records also. If no affidavit is filed also with the records, they will argue.
Thank you, my lord. Much obliged.
Item number 25.
Your Lordships, here I want to pray for additions to add state as a respondent. Inadvertently, I just missed because the impugn order was passed by the deputy commissioners.
Yes, so?
So I want to add state as a party because this is a writ petition.
You want to add?
Yes, state.
State as a party?
Yes.
For that, you have to file an application.
Yes, I will file an application.
Whom do you want to add?
Secretary Panchayat.
Learned counsel for the petitioner submits that he would like to file an application to implead the secretary. Which panchayat?
Gram Panchayat. Panchayati Raj.
Secretary to the government of Arunachal Pradesh. There's a department like that? Mr. Riram?
Panchayati Raj department is there, Your Lordship.
Yes, there is a Panchayati Raj department.
I think, Your Lordship, the secretary GA would be appropriate, Your Lordship, to represent the government, Your Lordship, to represent the state, Your Lordship.
No, first they have to implead them, na? Without impleadment, nobody will appear.
Yes, Your Lordship.
For impleading the secretary, Gram Panchayat.
Gram Panchayati Raj.
Panchayati Raj. And for
Gram Panchayat is already a member party here.
Panchayati Raj, not Gram Panchayat, and for which he prays for a week's time. Praise the Lord.
And Your Honor, there is a stay that they should not be replaced by third party, the petitioner should. And thus entry may be open, kept open.
Okay. In view of above, list the matter again after a week.
Can it be 23rd?
Oh, you want a
24th? 24th.
In view of above, and as prayed for, list the matter again on 24th March 2026. interim order passed earlier shall continue till the next date of listing. What is your good name?
DK Deori.
You write his name, okay? Learned counsel for the petition, Mr. D.K. Diori.
All right, Your
All right.
Item number 26.
Your Lordship, I'm for respondent number 2. Your Lordship, my submission would be that in the petition, page number 7, para 10, they have stated that it is submitted that the Arunachal Pradesh Public Service Commission is ready to furnish those records which are available and if not weeded out. But once the records are weeded out as per the rules and procedures for weeding out of the records, then the same cannot be furnished to the applicant. Your Lordship, my submission is this, if they have not destroyed those documents, then it may be provided to us. And if they have done so, then they may show some evidence as to the procedure and the steps that they have taken to destroy those evidence.
You are for respondent number 4.
2.
Respondent number 2.
Yes, Your Lord.
And what about the petitioners, the APSC? Who's appearing?
No one is appearing. I'm
Yes,
quoting respondent number 1, my senior Mr. Arsaki, the standing counsel.
This is item number
26.
26. Respond, okay, Mr. Saike for respondent number 1.
Yes, sir.
Mr. Apang, I think he's not in his best of health.
Yes, Your Lord.
What has happened? Anyone to help him?
Miss N. Anju is representing Your Lordship in this matter, Your Lordship.
N. Anju.
And as for order dated 6/2/2023, Your Lordship,
Hmm.
she was supposed to file application impeding CBI, and further she was directed to bring on the records before this honorable court, Your Lordship.
Hmm.
However, she is not present today, Your Lordship.
Records is given to the CBI.
It is submitted like that, Your Lordship.
Hmm. Application was maybe submitted if so required. That was the observation, isn't it?
Yes, Your Lord.
But they have not submitted any application.
Not yet.
What is to be done then?
Maybe adjourn today, Your Lordship.
Their prayer may be not be allowed as one more submission that the section 22 of the RTI Act, it supersedes all the rules and regulation of any department, Your Lordship.
But Miss Anju has to be here.
Yes, Your Lord.
Because she's not here. What to do? They are the petitioners. Somebody, but why is it listed for hearing under the hearing column?
Last evening, I had a conversation with Anju, Madam Anju, and she informed me that the hearing has been done, Your Lordship. Only she was directed to place the record before this honorable court. She informed me like that.
So where is she? She has not come.
She was there in this morning, Lordship. She might have led this honorable court with some personality. She was here in this morning.
Okay, we'll list it again some other day then.
Yes.
Not sure, a short date may be given.
Miss A. Anju, Miss N. Anju, isn't it?
Yes, sir. I know.
Learned counsel for the petitioner is absent, although the respondents are represented. We listed on Monday. You inform her also.
Your Lordship.
We'll list the matter again on 16th March. Should it come for hearing or for under any other column?
I don't have any idea, Your Lordship. Anyway.
Oh, there's an order for final hearing, it says. That's quite.
Okay.
Okay.